Sure. Well, that's fine.
Test.
I will be joining you.
Yes.
Oh, really?
So I am moving on to services. Detour slowing me down this morning. Wow. So I got something, you got some bonus.
You gotta go there and make down and back and get around. That's what we were into that
I have talked to he is sitting in the original he's changed sign. And so
It must be all local. But I laughed as I was running back and just like me.
And so I think he had some specific question about bonus.
I don't know.
No.
You're fine.
Over to you.
I was
Okay, that was just good. Okay. Touch base.
Oversight Committee to order, and Jeff, are you prepared to take the roll?
I'm ready. Senator Peterson.
Sure.
Senator St. John.
Here.
Senator Carroll. Garrett. Sorry. I'm sorry. Senator McCoy.
Present.
Senator Schneider.
Here.
2 minutes of the last meeting were distributed electronically. Any corrections to minutes? Seeing none, those approved. Just a couple of housekeeping items. We are planning to adjourn today at 4:30, and we are going to take a lunch break after report from the DAS. With that, we'll get started.
I have a request. Looking at some of the material you've provided, there's some fairly detailed, complicated financial charts and things here. And I'd like to request that after Director Lyons' testimony, the DAS be given just a few minutes to respond. I think it would only be fair. Some of that is detailed and complicated enough that I think they'd be the proper ones to comment on. I just would like to ask that the committee give them just a few minutes to respond.
And thanks for your request tonight. We will have you on the consent for the DAS to respond.
Thank you.
The Des Moines Register editorial board recently wrote, many years ago, Iowa erected a firewall to protect state employees from the shifting whims of bosses elected through the political process. Today, that firewall is under attack. That should concern all Iowans. Governor Branstad's attack on that firewall began almost as soon as he returned to office with the start of his multi-year effort to force Chris Godfrey to resign. Godfrey was not a member of the governor's staff. Chris Godfrey was appointed to a partial term by Governor Vilsack in 2006 and was confirmed by a majority in the Iowa Senate. He was reappointed by Governor Culver in 2009 and again confirmed by the Senate to a 6-year term that was supposed to insulate the position from partisan politics. When Governor Branstad took office, he demanded Godfrey's resignation as part of a wholesale partisan house cleaning, something that did not happen under Governors Vilsack and Culver. When Godfrey refused, Governor Branstad retaliated against him, cutting his pay from $112,000 to $73,250 a year, the lowest allowable amount under state law. The governor also vetoed the deputy commissioner position and cut Godfrey's salary. Despite Governor Branstad's unrelenting hostility and harassment, Godfrey's excellent work for the state of Iowa resulted in his appointment to a similar position on the national level. Godfrey moved up while Governor Branstad continues to charge Iowa taxpayers for the legal defense of his actions. Not only did Iowans lose the services of an excellent public servant, but Iowa taxpayers have also had to foot the legal bills of more than $500,000 so far. This week, we will consider evidence and hear sworn testimony about the operation of Iowa workforce development under Governor Branstad's political appointee, Teresa Whaler. We will consider evidence and hear sworn testimony from administrative law judges indicating that Director Teresa Whaler interfered in legal hearings on unemployment benefits, hearings that must be impartial according to federal and state law. We will consider evidence and hear sworn testimony that Director Whaler sought to reclassify the Chief Administrative Law Judge's position from a merit-based position to a political position, once again eliminating an essential political buffer. Imagine pleading your case before a judge whose continued employment depends on pleasing partisan politics. When the U.S. Department of Labor objected, the Branstad administration, for budgetary reasons, eliminated the position of Chief Judge, although the Bureau was operating within its budget. When Director Whaler assumed direct supervision of the administrative law judges, one of her first requests was to ask these judges to take steps to help employers win more often. The Branstad administration's campaign against unemployed Iowans has been hard to understand. First, local workforce offices across the state were closed. Then came the effort to attack the legal deck against those seeking unemployment benefits. And now we've learned gag orders were issued to Iowa workforce development staff to cover up a system malfunction that jeopardizes the integrity of the entire department. These issues should be sounding an alarm for Iowans to see what we can expect from Governor Branstad's concerted effort to politicize Iowa government. In his unprecedented effort to turn state workers from public employees into partisan political hacks, Governor Branstad has transformed more than 300 merit system positions to at-will employees. Iowans deserve a government that works for all of us. Iowa's public servants are the people who monitor our water quality, oversee spending of our precious tax dollars, and inspect facilities where vulnerable elderly Iowans live. Our public servants should never be afraid to do their jobs and tell the truth out of fear that they will upset the governor and his political cronies. We are seeing damaging effects across state agencies and departments from the governor's campaign to rid our state of hundreds of merit employees. In summary, today we will hear and examine how Branstad's administration's campaign to reintroduce the discredited oil system to Iowa state government affected one department. I believe this evidence and sworn testimony is a warning of the problems we can expect of all state government unless significant nonpartisan reforms are enacted. First, however, we have a bit of cleanup to do from our previous meetings regarding DAS cost-saving measures. We have previously questioned the leadership of Governor Branstad's Department of Administrative Services about their cost savings as it relates to outsourcing certain functions from architectural and engineering service to purchasing agreements for specific construction contracts. DAS has provided this committee with testimony on multiple occasions asserting that its reduction in force of state employees has saved the state and its agency significant money. The nonpartisan Legislative Services Agency conducted its own review, and we will hear the results now. I'd like to ask Director Iowans to provide the committee with a briefing and review of the expenditures by the Department of Administrative Services 2009 to 2013 issue review, which committee members you should have in front of you. Thank you, Holly.
Thank you for having me here this morning. I believe all of you have copies of the issue review. It was published several weeks ago, so I'll assume that you and or your staff have had a chance to read it. It was written by Dwayne Ferguson of our staff. Has recently retired after 34 years of state service, 30 years ago with the Iowa Senate. He did staff the administration and regular budget subcommittee. I'll give you a quick overview of the issue review and then open it up to questions. If I can't answer your questions, I have several staff members here today that can. They are specialized in like FTEs and I've got the current staff member of DAS, current staff member of admin, Ray Stubb here. Although I'm not sure, he doesn't know all of Dwayne's area, but he might be able to help out. Those are Dave Reynolds of our staff, Lon Robinson, and Dave Keaton, so they may need to jump in and help me with questions. So first, why did we write the issue review? In all honesty, it started out as just a fiscal update blurb as part of our oversight responsibilities. If we see something that we're not quite sure of, we might blurb it, we might put something out there and generally just the facts. He was also getting numerous questions from legislators and staff about cost-saving actions at the Department of Administrative Services. It's not a new issue. Dwayne had written 2 previous issue reviews, one in January 2013 on cost savings in the Department of Administrative Services, and one in December of 2013 on contracting for services. The topic of cost savings at DAS came before the Oversight Committee last session, and Dwayne noted that some of the numbers presented to the committee and to Dwayne in response to questions were not consistent with the numbers in the I-3 budget system. So as part of LSA's budget oversight responsibilities, Dwayne decided to write a memo to the Administrative and Regulations Budget Subcommittee, examining the expenditure information in a straightforward, concise manner. It was decided to issue the draft memo as an issue review to reach a larger audience and answer more of the questions that we were receiving. It's a very broad look for examination. It looks at total expenditures and trends for the department and for state government, and focuses on operating expenses only. As you know, DAS has a number of clearing accounts, revenue accounts, etc., that were not included in this overview. The info in the issue review is from the I-3 budget system. Several things, observations were made, and I hesitate to call them conclusions, but these are probably 5 or 6 things that can be deduced from this issue review. It concludes that a more detailed examination would be needed to determine the efficiency of the outsourcing. And these are in note to the order. Statewide expenditures and DAS expenditures are growing for the period fiscal year 2009 to 2013. The DAS workforce is shrinking, down 17%. The overall state workforce is growing, up 2.1%. Data suggests that the DAS is keeping or hiring higher paid employees and reducing the number of lower paid employees. And finally, we looked for a pattern. An increase in outside sources would suggest that personnel costs would decrease, i.e. if you're outsourcing your employee, your contracts, if that number is increasing, you would assume that your personnel costs would decrease. And in this case, they did not. But it doesn't go into detail, and that wasn't the intent of this review. It did not look at contracts alone. There could be reasons why costs are increasing, such as pay raises, cost of benefits are increasing. So we would really need to drill down to try to find the reasons why these costs were increasing. We're currently looking at an architectural outsourcing review. Ron's working on that. Specifically, the percentage of administrative costs paid on current contracts. Let me start over. Okay, we're currently looking at architectural outsourcing, specifically the percentage of administrative costs prior to the current contracts compared to the administrative costs on these current contracts. As you can imagine, it's extremely difficult to that because when you have change orders, just comparing those costs is a challenge, but Ron is working on it. We hope to have that done in a month or so. So now what I'd like to do is just briefly walk through the tables in the issue review and tell you basically what they say. Table 1 on page 2 looks at DAS operating funds for the period fiscal year 2009 to 2013. The expenditures by fund. They are up $5.9 million, or 5.5%. The largest categories are in IT and other funds. Table 2 just slices that information a different way. The grand totals are the same as you can see, but this looks at it by expenditure. Outside sources increased beginning in 2011. They're up 79% in 4 years. But the personnel costs did not decrease in a corresponding fashion as you might expect. They went down for 2 years and then up for 2 years. And the net result is that they're down about 1%. Table 3 shows expenditures for all of state government. Shows that expenditures are up 7.2% over the 4 years. This pattern is different than the DAS pattern, which was up for 2 years, a very slight increase in the 3rd year, and then down in the 4th year. Table 4 shows the number of employees, Department of Administrative Services and statewide. It also shows cost per employee. DAS, number of employees have decreased all 4 years. In the state, the number of employees decreased for 2 years and then increased for 2 years. DAS, cost per employee dropped for the first year and then has increased the last 3 years. The state cost per employee has increased all 4 years, but at a significantly lower percentage than Department of Administrative Services. Table 5 looks at higher paid positions versus lower paid positions. And we specifically looked at grade 13 because that's sort of the definitive line between management, professional, and highly technical positions. This table shows that more lower paid positions were eliminated over the last 4 years. And again, I need to stress it's a very broad conclusion, very broad examination, and it actually probably raises more questions than it has answers. And hindsight's 20/20, and my vision looking back is if we were to issue this again, we would make a much more detailed report given the time. So again, this is just a very broad view. Just like to open up to questions.
Thank you, Senator McCoy.
Yes. Holly, if we could go to the conclusions on page 5. And I, again, recognizing these are broad conclusions, it appears that DAS expenditures are growing by 17.6% in the last 2 years. And when we look at the expenditures, that's everything all in, right?
Yes.
So across,
it's all operating expenditures.
yeah, that's all operating expenditures. And if we look at other departments in state government, what kind of growth rate are we seeing?
I don't have a specific answer to that question. I just have the overall growth rate for all of state government.
7.2% over the last 4 years.
Right.
Okay. So just using that analogy, I guess that's my cause for alarm. Is if in fact DAS has been in on several occasions and told this committee that they've saved 15% over the past 2 years by implementing their new strategies, and in fact the numbers don't prove that up. I mean, that's very clear to me. It's a 17.6% increase without drilling down into the specifics of just apples to apples. When we look at other growth rates in other departments in state government, I think it is a fair comparison. If state government has grown at 7.2% and DAS has grown at 17.6%, and we're using the same measure for growth, I think it's a pretty clear conclusion that DAS has not saved money, that DAS has spent more money than they've saved, and that DAS has in fact mischaracterized to this committee their savings. And I think that ought to be a wake-up call for all the members of this committee. And I hope that when DAS, through unanimous consent, answers questions from this committee, that Ms. Lyons will remain at the table. Thank you.
Thank you, Madam Chair. Thank you, Director Lyons, for your information. First of all, we have had some correspondence back and forth over this issue, is that correct? And one of the questions I raised that goes to Senator McCoy's point was that your analysis does not take into account any savings that might have been realized through the changing the process that DAS uses for state construction projects and doing away with the general contractors and replacing them with, I forget the term, project managers or whatever. And isn't it correct that you said that your analysis didn't address that issue and you couldn't say whether there or not there were savings in that area?
That is correct. It's a very broad overview. We're not attempting to say whether certain processes saved money.
Well, and in fact, your analysis doesn't even take that into account at all.
No.
So, Senator McCoy's broad sweeping conclusion that this proves that DAS didn't save any money, that's not correct, is it? This analysis does not show that at all, does it?
Senator, I think it does raise questions. When you look at overall tables like this, like, as you send emails back and forth that make very broad conclusions. I don't necessarily want to speak to Senator McCoy's assertion. I think we tried to just lay out the facts, looking at overall expenditures. We did not look at, you're correct, we did not look at the processes. We also didn't, I mean, some of these processes are new, so I think it needs some time to review them to see the cost effectiveness.
Well, let me ask the question a little differently. Let's just hypothetically say that through the elimination, and your figures here don't show and don't even address the question of saving fees to general contractors in construction projects. That isn't even part of your analysis, is it?
No, it's not.
Okay. Now, let's hypothetically say that by changing the way DAS did business, that they had savings, substantial savings, because they don't pay the general contractor's fees. Your analysis wouldn't show that at all, would it?
I don't believe so. I might want to call them on. I don't know that that would necessarily be reflected in these numbers.
The overall, Dwayne's issue review addresses the overall expenditures by the agency. When you say that it doesn't include any outsourcing, any other type of savings, those savings are reflected in the overall data. It doesn't specifically address what items are in, what items were less efficient, which items are more efficient. But it does include any savings resulting from the outsourcing. So this particular paper does not address construction management agents. It addresses the overall issue, and any savings is reflected in the overall bottom line dollar. And I'm working on the issue review, as was stated, to address specifically construction, the CMAs.
Your answer to me kind of confuses the issue rather than throwing more light on it. This study does not even purport to address the question of whether there were savings on construction projects because of the elimination of general contractors. Isn't that correct?
No.
No?
No,
Where in this study, in these figures, do you reflect the cost of construction projects that the state has engaged in during this time, not using general contractors? Where do you show those figures?
The overall, you'll see in the issue review that it addresses specific line items. It addresses personal services, it addresses outsourcing, and to the extent that those are where those expenses are, where those savings would be, it is addressed in the overall number. So if you save money doing outsourcing of something, that would reduce the bottom line expenditures. However, in this case, the overall thing for the agency has been an increase in expenditures. It doesn't indicate whether they are doing more work, whether they're being more efficient, They're just spending more money. So the overall, to answer your question again, is the savings or not savings from outsourcing is addressed in the overall cost because those expenditures are listed in the overall table. So it doesn't get to the question. I mean, talking about this paper specifically addressing the CMAs, it doesn't do that.
And if there were savings in building construction projects, this paper wouldn't reflect that, would it?
It does.
Where?
In the
Show
bottom,
me where
in the
it's
bottom,
on.
in the bottom line. You'll see the specific line items are listed out: personal services, outside services, and those are all administrative expenses relating to everything, not just CMAs, but every type of outsourcing, every type of personal services. It's all rolled together. It is a small part of the overall operation of the agency.
Are you talking about table 1? Which table are you talking about?
Table 2 specifically addresses personal services, salaries. It addresses outside services.
All right.
And there are the CMAs actually, they fall within different categories. Other than that, they do other things. But overall, those total expenditures prior to the CMAs being created and after the CMA created, every single expenditure for operations is listed in this table. So those CMAs is a small portion, and this document really cannot be used to determine or does not state anywhere any conclusion about CMAs.
Do you have an idea of what the cost of state construction projects was during these years?
Yes. And that's a paper will be coming out.
All right. And roughly what would that have been? Just rough figures.
100 million. It depends. It fluctuates substantially from year to year.
All right. Let's just say it's 100 million. Now, you did not have the cost of general contractors for that 100 million in construction projects. Would that be correct?
No.
No, it is not correct, or no, you don't have the cost?
The general contractor is, under the prior establishment, was not a part of operations. It was a part of the building project.
Right. So that wouldn't show up anywhere in your chart here at all, would it?
You're right. This does not address anything other than the overall operation of the agency.
So, back to my hypothetical. If there had been savings in construction projects, which would affect the cost of the construction projects, by not using general contractors, your chart wouldn't show that, would it?
Correct.
Okay, that's what I'm trying to get at. So, to draw a conclusion that DAS is spending more under their revised way of doing business than they did before, you don't know that because we don't know what, from your chart here, we don't know what savings there might have been in those building projects by doing away with the general contractors. Isn't that correct?
So, Senator, the paper addresses the overall expenditures for the agency, and so, yes, the total operating expenses, whether it's going to CMAs, going to fleet management, going to every single thing that the department does for their operations is reflected in this document. And the savings you are talking about will be reflected in the next document that I am producing.
All right, so what you have done here, you are showing the cost of the project managers. in your figures, correct?
Correct. So under this scenario then, since the CMAs, the work that was done by DAS employees in the past is now being outsourced. So all those costs though are still then reflected in this document.
Well, not all of them. The cost of the CMAs is reflected here. Now,
Correct.
Now, here's the problem, my problem. The CMAs took the place of the general contractors.
Correct.
Okay, so now, in the current years, the recent years, you have added the cost of the CMAs to the operating expenses of DAS. What you have not done, and therefore, this is why I'm saying it's not a fair comparison, you have not shown the savings from doing away with the general contractors. And that doesn't show up anywhere here because that's part of the cost of the building project. So what you have done, you have added a category of expenses to the operating expenses for the CMAs and ignored the fact that that expense may be substantially less than the expense of the use of general contractors, because the general contractors don't show up anywhere here. Isn't that correct?
I think what we need to do is go back to the purpose of the paper. And the purpose of the paper
would you
was to
please answer
address.
my question,
Point
rather
of order, point of order. You know, I think that what's happening here is a good exchange. I think that the badgering needs to stop, and I think that it would be good if our nonpartisan Legislative Fiscal Bureau has an opportunity to answer the questions in complete detail before another question is asked. So.
Point well taken.
And I appreciate your question. I understand where you're trying to get to, and my answer was being responsive to your question. If I could continue.
I'm sorry. Please.
And that what I feel is that you're trying to analyze something that is not addressed in this paper. The paper's overall statement was to look at a goal that was stated by DAS, which was to reduce expenditures by 15%. That goal could be interpreted by people in different ways, and it may have been interpreted differently for this paper than DAS would now say, or the governor would say that it was meant to do. But overall, so it was looked at as though they were saying they wanted to cut expenditures by 15%. So the paper looks at overall expenditures. It doesn't look at specific projects, initiatives, activities, products. It doesn't look at any of those. It looks at, are they spending more now than they did at the start? And that's all it does. This paper is not intended to address specifically the construction management. I will be doing that in another paper, and I think you'll appreciate it. I believe it will address everything that you're talking about. It's not going to be as straightforward as I was hoping. I was hoping for a one-pager to just set it out and say, here it is. It's not going to be that way. There are several things, and I want to compliment DAS for being cooperative in that work, and so hopefully we will have a paper that we will be able to agree with DAS as to what the impact is of the construction management. But this document itself was to address the overall expenditures by DAS. And so that's what it does. And so the conversation on construction managers would be better served with the issue review that I'm working on.
So would you at least concede that it's possible, let me say it this way, from the taxpayer's point of view, the taxpayer pays expenses of DAS, they pay for the building projects, they pay for all this stuff.
Yes.
From the taxpayer's point of view, is it fair to say that this analysis does not show that the taxpayers are paying more now overall, including paying for building projects, than they did under the old system? Is that a fair statement?
I would say it does not address anything other than operations, so
Well,
I can
it's
say-
a fair statement then.
what was that?
It is a fair statement then.
Yeah, sure, yeah. It's
That's all I'm trying to.
okay.
I think we should wait for the full report on the subject area instead of asking around person to answer hypothetical questions. Are there additional questions from committee members?
Well,
Do you have more?
yes, I do. Director Lyons, another issue I wanted to address is the increase in state employees from 2009 to 2013. And could you elaborate on that a little bit and tell us what the figures show in terms of the executive branch versus legislative, judicial, and then within the executive branch, the Board of Regents, and as a prelude to this, is it fair, well, let me ask it this way, does DAS have control over the employees hired by Board of Regents, legislative branch, and judicial branch?
No, they do not.
Okay. So, could you tell us about the numbers of employees from year to year, 2009 to 2013, looking at the employees that DAS actually has control over? What's happened there?
I prepared a chart, and I have copies here. Give me a moment to find them. Thank you. I prepared this in response to a question earlier from Senator Garrett, and I'll give you just a moment to get the chart so that everybody's got it. Okay, what this table shows is the number of state employees, the grand total statewide. This is all employees, judicial, legislative, regents, has increased since fiscal year 2009 by 2.14%, or 1,119 employees. For the judicial branch alone, it has decreased by 7.77%, or 149 employees. The legislative branch over the same time period has reduced 24.43 employees, 5.73%. The executive branch, without the judicial and the legislative branches, has increased 2.59%, or 1,293 employees. The regions alone have increased 3,838 employees, or 13.87%. So the total executive branch net of regents, and I believe the other two, I'll clarify that with Dave, but I believe that's executive branch net of regents and the judicial and legislative, has decreased 2,545 employees, or 11.43%.
Okay, so of the employees that DAS actually has control over, the number is actually down by over 2,500 employees.
Correct.
It's gone down rather than up.
Yes.
Thank you. Thank you, Mr. Chair.
I want to clarify that though. The number of employees have gone down system-wide, but the study that we're looking at deals with the cost of employees within the department of DAS, correct? So you'll see that the cost of the employees has gone down by 1% in that department, just to clarify.
Well, one is numbers, and the other, you're talking about costs. I was asking about numbers. The numbers are down 25 executive department, a step, the board of regents.
Correct. I just want to make sure we're talking apples. Do you have any other questions?
No.
Senator McCoy.
Holly, I have a question, getting back to the point about when you look at processes inside of any agency in state government, my experience with this relates to how other departments have gained efficiencies, and those efficiencies are in effect savings. But when you did this analysis, what I heard Ron saying was the analysis was operating expenses. It wasn't, I mean, because DAS is such a sweeping, large, mammoth department, to take out just one area in the department and say, well, these processes were efficient, and so there were savings recognized and realized, and those savings should be reflected in an operating deal. I guess to Senator Garrett's point, if that's the measure of growth in state government, then I want to examine the efficiencies of every department and every program and every system improvement across the state, because what we're really trying to do here is give a broad overview of a measurement, and if you could just speak to that, I would appreciate it.
Yes, Senator, it's very difficult to analyze processes and where savings occur, because especially in something when you're trying to make something more efficient, you try to reduce the expense here, but like in outsourcing, you're going to have contracting costs will increase, your personnel costs should decrease correspondingly. But there's also, especially in DAS, there's so many other things going on. You've got printing and postage, and there's to isolate, especially with contracts and construction contracts, and I use the example of change orders and things change in the whole contract process. It's very difficult. We just wanted to look, and the question that we kept getting from legislators and staff was, are DAS's expenses going down? Are the expenditures going down? Are the expenditures for state government going down? Are they going up? And that is solely what we tried to show here, is total operating expenses. I understand Senator Garrett's point of view. We're trying to get down to that to actually show whether there were savings or not. But it is extremely difficult. And honestly, a program evaluation would probably be needed, and those sometimes take years to actually get down to find. This was meant to be a broad sweeping look. I admit, it raises more questions than answers.
Thank you, Holly. I think that the point here is as legislators, we use barometers to measure how things are going, and one of the barometers we measure is what is the rate or growth of government and expenses, and that barometer has always been to measure the operating expenses of each department, and that's how we determine where growth will occur and at what rate growth will occur in government, and we do that through the budgeting process. And so when the Department of Ag invents a new program that streamlines applications for manure management and saves taxpayers or saves users millions of dollars, we don't say to the Department of Ag, well, you've reduced costs by this much, so we're going to allow your operating expenses to grow at 17%, when state government's growing at about 2%. So I just think that we need to be honest from a fiscal standpoint. We need to be intellectually honest about how we evaluate programs and processes, and certainly I think that any program is worthy of highlighting and showing actual savings when it occurs, but I think that is separate than what happened in this fiscal issue update. And I think what happened in this issue update is we got a first-hand honest conclusion that BAS has grown at 17.6%, while the rest of state government has grown over the last 4 years at 7.2%. And I think if you can draw any other conclusion than that, good luck. Take your hypotheticals and your analysis and prove it up. But this paper is sound, and the work that went into this paper is sound, and DAS has grown at a 17.6% clip. And that ought to be cause for alarm when they come before the committee and tell the committee that they saved the committee, they saved the state 15%. That isn't reflected in their operating expenses, and that's really how we measure departments in state government. So thank you, Holly and Fiscal Bureau, for your work, and I'll look forward to more analysis in the future.
Senator, you're right.
Thank you. In doing an analysis of this kind, is it normal procedure, is it or isn't it normal procedure for legislative services to contact the agency involved to get their input?
In a broad analysis like this, we can pull all of this information from the budget system, and that's what we do. But I don't believe we ran this one by the department because we had all the information from the budget system, which is actually controlled by DAS.
So you didn't contact them at all to get their input?
I can't speak for Dwayne,
Yeah.
Senator, I'm sorry. I can find out for you.
But as far as you know, they weren't contacted.
It was a combination of databases, our appropriations tracking and our I3 system. We made sure that the numbers tied out, and they did. But I can certainly find out for you.
Yeah, okay. All right, Madam Chair, this is, to me, is disturbing because what has happened, and we know this from prior testimony, under the old system, the expenses of building projects were all outside of DAS's operating budget, completely. You'd have a general contractor, they would make a bid, different contractors make a bid on a project, and somebody would be hired. The general contractor's fee was paid as part of the building project. Didn't show up in operating expenses of BAS. That's the way it's been over the years. Now we have a new system. We have
That's not accurate.
project managers hired
It's not accurate.
to overlook construction projects in lieu of the general contractor. The project manager's fees, as I understand it, and DAS can fill me in if I'm wrong, is included in the operating expenses. The savings by eliminating general contractors would show up in the cost of the construction projects. They would be less. So what we've done, we have added a whole new category of employees in the operating system here, the operating figures, not taking into account that they were a substitute for general contractors. The fees to the general contractors are not paid, but that shows up in the cost of the building project. It does not show up as part of the operating budget. And that's why we're misleading by ignoring that fact and just focusing on the operating budget of DAS. Thank you.
Senator McCoy.
Senator Garrett, the statement that you made is just not accurate. In the previous DAS expenditure line, there was an entire professional service division in state government which were reflected in the expenditures under the operations side of the budget. That has been eliminated, and the project management that you're seeing in the expenditure line was added to the overall budget to replace the professional services division, which was eliminated. So it is an apples to apples comparison, Senator, with all due respect. What you stated is just not accurate because you eliminated an entire professional service division of state government. You saw all those layoffs of those people, and we saw the chicken scratches that they brought in here that said they'd save $700,000 in salaries, and you've touted that over and over and over again. Well, that's all reflected in the budget of expenditures, and the expenditures here of project managers that were paid from those expenditures under the operating expense form are still the same expenses, but just using another source of professional management. So those savings are already reflected. So to state that they're playing games with the numbers isn't accurate. You're playing games with the numbers, in my opinion, by not reflecting the layoffs and the elimination of those positions and salaries. And that's the point I think that needs to be made here, because I think you need to compare apples to apples, and that's what occurred.
One more. I'm sorry, but I need to respond. You are correct. There were some employees that were laid off. So under the old system, that's true. You paid those people, plus you paid the general contractors.
Plus we paid them hush money and settlements on top of that. So I mean there was no end into the flow of money.
There was one instance that you came up with that you might call hush money, where specific money was paid for confidentiality. One instance of that.
Oh no, there were many.
No, there were not.
Yes, there were.
There were confidentiality agreements as part of the settlement.
I'm calling it all hush money. Right?
Well, all right, that's a good definition.
Because we were sloshing around with so much money. I mean, we dropped to $500,000 in a matter of months, paying out employees and found unlimited sources of funds to pay these folks. So, Senator, with all due respect, I know you don't like the news that you got today. I know that learning that 17.6% increase in state spending isn't what you want to use to defend this government and this administration's lack of management and oversight and fiscal responsibility. But the facts are the facts. And, I say sometimes you got to swallow hard and move on.
Facts are the facts.
There's several things.
And the point is, we are only looking at part of the picture. And I think that's been brought out by the testimony here. This doesn't take into account the savings on the building project, which is millions of dollars, which completely dwarfs the figures that we're dealing with here.
We'll see.
Are there any further questions? Do you still wish to ask unanimous consent for the department to respond?
Yes.
On good order, seeing no.
Thank you, Senator. As many of you know, prior to going to DAS, I spent about 20 years in the legislature, and I have the utmost respect for the work that Holly and her team does. I worked closely with them for a lot of years. To answer Senator Garrett's question, no, we were not contacted about this. And it's unfortunate because Senator McCoy talked about comparing apples to apples, and unfortunately this memo does not do that.
I'm sorry, do you have a specific question that you'd like to ask the department to
I would like to have Lon respond to the points that we've been talking about here. He's in a unique position. He understands a lot better than I do the finances involved, these figures involved, and that's why I asked if he was allowed to talk about them, because he's intimately involved and was not contacted when these figures were prepared, and I think it's only fair that he be allowed to respond.
Point of order, you know, the assertion that we're gonna go tit for tat, here's my problem with it. The department has been in twice, and numerous top heads of the department have testified, including an enormous amount of analysis that went into where the cost savings were calculated, and their assertions that they had saved the state government 15%. I think that if there's a specific question, we should ask a specific question, but to have the department testify again today after hours and hours of testimony, to me, given the nature of the other issues before us today, is duplicative and unnecessary.
Well,
Senator, do you have a specific question with the department related to the issue?
we'll do it that way. Thank you. Lon, I would like you to respond to the financial charts showing the different expenditures by DAS, and I want to ask you, are these ongoing expenses? Are there any one-time expenses?
Yes, absolutely.
Are there any special circumstances? I'd like to know the detail that is behind these numbers.
Yeah, the memo that I passed out addresses 3 of the assertions that were made in the memo, and then our response to those assertions. The first one being the Senator McCoy's mention of the 17% increase. $9 million of that was for other agencies paying in for vehicle purchases. That's not DAS's money. Yes, we collect it and we spend it on cars, but it's for DPS, so the troopers can have new cars, DOC, DHS. That's $9 million of the increase right there. Now, yeah, granted, DAS did buy a few cars, but of the $9 million, it's a very small amount. And the reason for that was, after the across-the-board cut, agencies stopped paying in because they said, don't buy vehicles. Use your vehicles longer because we're in a budget crunch. After we came out of the budget crunch, they started paying in and buying vehicles again. That's $9 million of the increase. Another $8 million of the increase is for the legislatively mandated consolidation of IT that's being headed up by Bob Woodrat. And a lot of that is one-time infrastructure purchases related to IT. They've also taken over other departments like the Department of Revenue. They've taken over their IT. They've taken over the Department of Natural Resources. So obviously the Office of the Chief Information Officer's budget is going to grow substantially, but at the same time, those other departments' IT expenses are going to decrease. So that explains the all of the 17% increase from 2011 to 2013 in just those 2 points. You're right. It is very confusing when you're talking about the savings from the construction management, because the operations side, as Ron Robinson said, is in the analysis, but the construction savings side, which is the major piece of that, is not in that analysis. And I look forward to Ron's review of that, because I think it's going to show substantial savings on the construction side. This doesn't address construction at all, and that's the main thing that the Department of Administrative Services does. The fact that it claims that we've saved more on, or spent more on outside services than we've saved in personnel costs is simply not true. And we go back to the outsourcing of janitorial, which saves $236,000 a year. That's a net figure, net of those salaries, and no one was laid off to do that. It was just holding open positions. We've talked about the reorganization of construction management and the savings there. And then the assertion that we've been replacing lower paid employees with higher paid employees is simply not correct. When 43 employees took the early retirement incentive back in 2010, the majority of them were lower paid employees. because they thought it was a good deal to take that 5-year incentive and the health insurance to retire early. Those positions were not replaced. That's how we're down 71 positions since 2009. We're doing more with less. And so, unfortunately, just pulling numbers out of I3 and saying, you've increased your budget by 17%, it's just not accurate.
Thank you.
Senator Copeland.
Ron, if we could look at the issue review, page 2 of issue review under general fund, Department of Administrative Services, under the table 1, I see IT expenses, and I'm following across from 12 to 13. And in FY12, we're showing $16,410,000. In FY13, $17,188,000, which is a net change of 4.2%. Centralized purchasing at FY12 number $30,141,000 to $35 million.
I'm sorry, Senator, which table are you looking at?
I'm looking at table 2, table 1 under the general fund, page 2. And then I'm looking at the vehicle fund in FY12, 3.6 to 3.9.
Well, Senator, the comparison, the 17% figure, isn't from 09 to 13. It's from 11 to 13. So you have to look at the FY11 column and compare it to the FY13 column. That's where you see the $9 million difference on vehicle depreciation. That's where you see a $5 million difference on IT.
Show me that. Show me the $9 million on vehicle.
FY11, the vehicle depreciation, 14.633 million. FY13 vehicle depreciation, 23,602,146, $9 million.
And where is that?
It's under the line of vehicle dispatcher revolving fund, vehicle depreciation revolving fund, and motor pool revolving fund.
Okay.
And as I explained, that was because we made the decision, we have a tight budget. Instead of laying off people, we're not going to buy cars. You're going to use your cars longer. And then we got to the point where, troopers needed new cars, agencies needed new cars. They had to start paying back into that vehicle depreciation fund. That's not DAS's money. We control it because we buy the cars, but it's for those agencies that paid in for that.
So your contention is between 2011 and 2013 that there was $9 million new additional dollars paid into the fund.
It's not my contention. This is LSA's number.
No, I understand that. I'm not. That was not a hostile question.
Okay. Sorry, Senator.
Your contention is that $9 million reflected new dollars into the fund.
Absolutely.
Okay. And that reflected in more spending on behalf of the department.
Yes, because that fund is considered a DAS fund, but it's not our money. It's DHS's money. It's DOC's money.
Well, none of it is your money.
Well, there's a little bit.
Very little. So the point is we spent, to Legislative Fiscal Bureau, we spent 17% more money of other people's money, which all came into DAS, and I get that. So what we're saying is, yes, state government over that 4-year period grew at 7.2% in terms of spending, operating expenses, and under that same period, DAS grew at 17.6%, and your special cost for that is we start buying cars again. And so therefore,
to draw any conclusion about the operation of the department and the amount of vehicles that we purchase, you couldn't have more apples to oranges than that.
No, I understand that, but again, I'm just looking at this from a strictly, here's the barometer. this is how much we took in, this is how much we spent. We spent over that same period of time at 17%.
Fair enough, Senator, but if we move the vehicle fund to the Department of Management, would you say the Department of Management spent $9 million more?
Yes.
Okay. Well then, in that case, I think saying that our operations were increased by 17 million is just not accurate.
Well, again, this was a measure of spending and operations, and that's what's being measured. Separate issue reviews, separate analysis, systems improvements, all of those serve as factors. But again, to say that Legislative Fiscal Bureau somehow misrepresented the accuracy of the spending.
I'm not saying they misrepresented anything. I just said you can't draw the conclusion that our operations increased by 17 million by including $9 million of vehicles that were purchased for other departments. That's all I'm saying. I'm not arguing with these numbers. I'm just arguing with the conclusion.
Fair enough. I just think it's important to remember the purpose of the issue review was to measure spending and operations cost, and that's what they were trying to do.
Fair enough.
And those line items were in your budget because DAS, you know, in the system had responsibility for those purchases.
That's correct.
And therefore, you can certainly make that case. I just think that you know, every other department could also make cases for why they delay improvements or spending in their own departments during tough budget times, whether that be they deferred IT spending or they deferred other spendings at the same time. So to suddenly say, well, you know, we only want to be measured on these areas. You know, you happen to be a mammoth department, maybe too big, and quite frankly, that's something we're going to have to give some consideration to. Is how we might restructure DAS so that it isn't so large that, you know, it can't be responsible to legislators and have oversight. And I think that one of the things we're going to have to look at is all the utility fees that are being collected by DAS and how those fees are coming about and how those fees are determined and how those increases are determined and how those funds are used and how they're commingled and how rebates are used by the Department of Administrative Services. So I think we've got
Senator, we'd welcome that review.
I think we've got a lot. I think we got a lot of legislative work to do next year. A lot of legislative.
We'll be happy to give you any information you need on all of those subjects.
Very good. Very good. I know you've always been more than willing to come before us and present your data. And I've got to say that at times I feel your data has been flawed. And I think that we need to spend some time and really spend some time to prove up everything that is being presented as data now. Thank you.
Thank you. Well, to put this in just a little bit different perspective, on these vehicle purchases, who makes the decision as to how many vehicles to purchase? Is that a DAS decision?
No,
who makes that decision?
The department directors. So Director Palmer at DHS says he needs 100 cars. He puts the order in. We get the vehicle depreciation money to pay for those cars, and then we get those cars out to DHS. That's how it works.
Thank you.
Director Lyons, one of the questions that our committee continues to grapple with is the utility fund, where the supplements were paid from. Could the Fiscal Bureau Legislative Services Agency give committee members a listing of all of the funds at DAS that are defined as utility, so we have a better idea of different fees being paid in from various state agencies and how those are placed within the department.
Senator, I would direct you to our website. We just had customer counsel for the FY 16 and 17 rates, and we have a link right on the front page. It says service rates methodologies, and it shows every service line and what we charge. It'd be a very handy document. It's about 3 pages long. And we'd be happy to provide LSA with whatever they need on.
We are also working on updating analysis, not analysis, but it's a table we did probably 2 years ago on fees. So the fees spent from, I think, in that analysis, we went back to 2009. We're going to update that through 2014. We're actually working on that right now.
And we'll be the first to admit, we're very unique in the fact that we get very little general fund appropriation. 95% of our money comes from other departments. And we want to be very transparent about where that money is coming from and what it's going to.
Yes, I think we all agree that we need more transparency on those funds. Are there further questions from the committee members? Senator Schneider.
Actually, I just want to thank Mr. Anderson for coming in, and I think it would be a more credible measurement of that the DAS's effectiveness to isolate spending decisions over which it has direct control. So I think that the numbers Juan provided are very helpful in that regard. Thanks.
Thank you, Senator.
Additional comments from committee members? Thank you, Director Lyons, and for the committee reporting committee, and we will break for lunch and we'll be meeting at 12:30.
hearings, and we hold a hearing with the parties that's digitally recorded.
Okay, to back up just a little bit further, the people who might have a claim would be people that have been laid off, fired, or something has happened as far as their employment goes.
Right, either a voluntary quit, an involuntary separation due to layoff or the discharge. There could be other collateral issues as well, but those are the primary categories.
And then who makes the initial decision as to the validity of the claim?
Well, we do after we hear the evidence from both sides or the sides that wish to participate.
Okay, maybe I misunderstood. I thought you said that you handle the appeals.
The
So
original,
who makes the initial decision?
the Benefits Bureau has fact finders or workforce advisors that hold a telephone interview, a fact finding interview. Then they issue a very brief decision indicating allowance or disallowance of benefits. And then if the parties appeal, either party appeals, then it comes to our office.
And do you know roughly how many of those decisions get appealed? Is there any rule of thumb, or maybe not?
I'm sure someone knows, but I don't.
Okay, that's fine. Now, do you have policies? I don't know quite what the right word is, but are there standards that you use, legal principles in determining an appeal? How do you decide an appeal? What are the things you take into consideration?
Well, certainly there's statutes and administrative rules,
Okay.
and any case law that there might be on the topic.
Are there policies in addition to statutes and administrative rules that the department has, or is it just the statutes and the administrative rules that you use? You go on?
Well, we don't have any policies, but we do like to find areas of consistency between the ALJs and certainly the Benefits Bureau tries to find consistency with their fact finders as well.
Now, going back, are there, now, what is the role, let's put it this way, what's the role of the federal government in your labor department?
My understanding is the federal government funds the Appeals Bureau 100%. Beyond that, I'm not terribly familiar with budgeting.
Okay. Now, do they have standards that you, in order to get that money, that you have to comply with?
Oh, absolutely. The U.S. Department of Labor has many guidelines that we need to follow. Some relate to timeliness, and my colleague, Judge Hillary, has more information about it than I do. They also have quality standards about how the hearing is conducted, how the decision is written, how the parties are treated, those kinds of things.
Do you have information on the timeliness standards and how, over the years, Iowa Workforce Development has complied with those standards?
That would be in Judge Hillary's area.
Okay. Do you have information on the percentage of times, the percentage of appeals that are decided in favor of the employer as compared to the employee? Do you have that?
No.
Okay.
I don't keep track of that.
Okay. You don't keep track of that?
No, but in my position as policy lead worker, I look more towards the how the hearing is conducted, if those DOL requirements are met, not the actual outcome of the case one way or the other.
Okay. Now, in your work, you've worked under how many different directives did you say?
I have it written down here.
Okay.
Three governors, 4 directors, 3 chief ALJs, 2 interim chief ALJs, multiple employment appeal board members, and 4 attorneys.
Okay. And I know you said you didn't have detailed information on issues of timeliness. Are you aware of whether there have been issues in that area over the years with workforce development?
Yes, absolutely.
And do you know the nature of those issues?
Well, our goal is to meet or beat 30 days from the appeal date. The person who put the appeal in the mail. And so we have 30 days from that date to hold a hearing and issue a decision to meet the requirement of the DOL standards. There are other ones beyond that. Certainly we have some postponements and other things that might delay that somewhat, but our goal is to meet 30 days.
Now, is that also a federal requirement, or do you know?
That comes from the DOL, federal DOL.
Now, were there times during your period of service here when the department was having trouble meeting that standard?
Yes, but again, Judge Hillary has more detailed information than I do on that.
All right. We've heard talk about tip sheets. Are you familiar with that term, tip sheet? And can you tell us what a tip sheet is?
Yes, I am familiar with that. I think it's become kind of a term of art, but tip sheets are not new. There's been an outline of selected issues in unemployment insurance law posted on the Appeals Bureau webpage for a number of years, I think dating back to 2010, possibly earlier. There has also been a list of frequently asked questions that apply to the parties, and that's also been available on the website. And the tip sheets more recently, I think are misnamed more than anything. They're simply a summary of the law, of the UI law on a particular point, such as work refusals or discharges from employment or voluntary quits, that give parties an idea of what the law sets out as a requirement to either gain benefits, eligibility for benefits, or to lose benefits. And so it's simply information sharing about what the law is, what's expected of the parties.
Now, are those only available to employers?
Oh no, they're posted on the website for any person, whether a party or non-party, a representative, whoever, an attorney, whoever would want access to them.
So, from what you're saying, I gather a person with a complaint or who thinks they might have a claim, they're not going to be sophisticated legally to be able to read the code, administrative rules, and so on. This is, am I correct that this is in kind of layman's language, so the person could look at these tip sheets of frequently asked questions and get some idea at least whether they've got a valid complaint or not?
Yes, and I would note that the vast majority of the parties in our hearings are represented parties, and so we need to be cognizant of our language that we use in decisions and hearings. And part of it is in the claimant handbook, and the employer information, and any information that we make available to parties. We need to make sure that it's understandable and have a minimum of legalese in it.
Do these tip sheets influence your decisions as an ALJ in any way?
Oh, certainly not. They're not, you can't make a decision without factual information from the parties. So you have to have the facts before you can make a decision using the law to apply the facts.
Are there other agencies in state government that use tip sheets that you're aware of?
I'm not aware.
Okay. All right. Are these tip sheets revised from time to time, updated?
We have somewhat. I have personally edited some, just because there was some grammatical and typographical errors that I saw that I wanted to correct so that we could best reflect the agency and the bureau.
And I suppose occasionally there might be a Supreme Court case, for example, on a particular point that might generate an update to comply with their interpretation of the law. Would that be correct?
Yes, when we have time, we do like to update those as soon as practical.
I wanted to ask you, in your career as an ALJ, have you had any of your supervisors or higher ups pressure you to decide a case for an employer or an employee?
Never.
Never. And if anybody did try to do that, would that impact the way you decide the case?
Well, I have a pretty varied background and in both sides of the political arena personally. I come from a background of multiculturalism, international living experiences. I have a lot of broad base of legal experiences, as you noted earlier, from perspectives from employers and employees. And I've never been afraid to speak up when I think there's something wrong going on. And certainly I'm not going to let somebody tell me how to write a decision. And if they try to, I would speak up and say something about it.
Certainly. Can you tell us what is the impact on the parties if the decision on their case is delayed? If an agency, if workforce development isn't current and is running behind the standards that are set for them by the Labor Department, how does that impact the parties?
I've actually given the CLE presentation, completing a legal education presentation on the issue of the timeliness and how that is a major factor that affects the parties. First of all, you're talking about claimants who have no income coming in, and they are oftentimes, by the time it gets to us, 2 or 3 weeks or more into the process of after their separation. They need an answer so they can tell their landlord that they're going to make rent next month. And they need answers so they can go and get food stamp assistance or something like that. They are on the financial edge and teetering generally by the time they get to us. So it's essential that we try to give them an answer as soon as we reasonably can. From the employer perspective, most of our employers are small businesses. They have payroll to meet. They need to know if they're going to be able to make their quarterly tax payments or quarterly statement of charges. They need to know if they're going to be able to order more supplies for the next quarter. They have all kinds of financial. They need to know if they can hire somebody else to fill this person's position that either quit or was fired or whatever reason. So it's really essential from so many perspectives that we hold the hearing and issue a decision as soon as reasonably possible.
Can you tell us currently, right now, whether your agency is meeting the standards that the federal government sets out? Are you current now?
I'll leave that to Judge Hilbert.
Okay. We've heard scuttlebutt about hostile workplace environment. Have you personally experienced a hostile workplace environment at the workforce development?
Not from any administrative perspective, no.
Okay. We have heard that some judges have worked at home substantial amounts of time.
Yes, I was one of those.
Okay, and can you tell us how much of the time did you work at home as compared to work in the office? And did that change over the years?
It did, and that's one of the reasons, quite frankly, that I returned from workers' comp back to UI is I had a small child, it was a single parent, working from home. It was enormously helpful to me, and it was a wonderful way to have that extra time at home with my child. He's now graduated from college and on his own, so that's not the perspective anymore, but certainly that was a huge advantage. But over the years, so I was working at home full time and would go into the office weekly to pick up files, drop off files, that sort of thing. Go into meetings, staff meetings, there weren't many, but I would go into those kinds of reasons. And then, I guess it was September of 2011 that there was an announcement that there were work home privileges were going to be completely eliminated or removed. And I also had moved from employment to Ames in 2003 under the understanding I could work from home at Ames and to benefit my family situation. And so that news hit very hard. I was not happy. And so that's when that happened, but it did end up being a full-time removal back to the office. And it wasn't until March of 2012 that we actually did start working in the office on a rotating basis.
So are you 100% working in the office now?
No, I work more than, Judge Hiller works full-time in the office. I work more than half-time. And then there's two new AOJs that work full-time in the office, but all of the rest work half-time in the office and half-time at home.
Now, did you have some kind of agreement, written agreement that spelled out the responsibilities and so on as regard to working at home and the conditions and so on?
There was supposed to have been, well, there was one that we signed and it apparently never got processed and handed back to someone in the administration, so I don't know whatever happened to that. But then we ultimately signed one of these.
Now, you said all of them we signed. When was that?
I can't remember. Not terribly long ago.
Oh, a year ago?
Yeah, within the last year, I believe.
Do you know if the federal government requires a written agreement with judges that work at home? Are you familiar with that?
No, I did check with our DOL liaison in Chicago, and she asked around about working from home and that sort of thing. There's not many states that allow it, so there's no particular requirement one way or the other.
Okay. So That's an unusual situation that judges be allowed to work from home.
Yes.
Okay. Since the work at home time has been reduced, has there been a correlation between reducing that time and the increase in the number of cases that have been handled? And per month or whatever it is?
Well, we started working in the office the third time. And that was in March of 2012. And then in June of, no, sorry, I'm going to be off the year. But at any rate, so in June of 2013, we moved from 28 hearings per week to 30 per week.
Well, so output has increased over the years as less time was spent working at home. Is that a fair statement?
Yes, overall, I would say that's accurate.
Is there anything else that I'm not smart enough to ask you about that you think would be helpful to the committee that you'd like to give us?
I think you've answered or asked questions on topic, so I have nothing else to add.
Okay, thank you very much. Thank you, Madam Chairman.
Senator McCoy.
Thank you, judges. Appreciate you being here today. Judge Hillary, can you tell me what a lead worker is, or what distinguishes a lead worker title? I'm sure I understand.
When the director decided to implement lead workers, she asked for volunteers, some of us volunteered, and she had topic areas that she wanted us to address. I addressed workflow, Judge Lewis addresses policy issues, and Judge Wise, Stephen Wise, addresses IT technology issues. So in addition to hearing cases, we also took on other duties or issues to address. For instance, mine was workflow, the timeliness issues, figuring out how we as an appeal unit could meet those Department of Labor metrics that we call them. Those metrics are imposed upon us by the Department of Labor. They're not a standard that we choose for ourselves. Am I going too far for your question?
Yeah, a little bit. The thing that distinguishes that title, I guess, does it come with additional pay?
It does come with a 5, 10, or 15% additional pay. The lead workers all get, is my understanding, 15% additional pay for the extra duties that they perform.
And you and Judge Lewis are the two lead workers.
No, you're forgetting Judge Wise is also lead worker, Stephen Wise.
I'm not forgetting anything. I don't know anything. So,
we're not the only two. And in fact, I think the director made it clear that there were other lead worker positions available if someone wanted to apply for them, and I don't know that anybody ever did.
How long have you been a lead worker?
Since July of 2013.
And how about you, Judge Lewis?
The same.
Okay. Okay. So, help me understand when you stated, Judge Lewis, and I'd like to also hear from you, Judge Hillary, about hostile work environment. You said not from the administrative perspective, and that seemed to be an incomplete answer to me. So I'm going to ask the next question, say, how might there be a hostile work environment at workforce development in any way?
I'm going to address it too. I haven't ever experienced a hostile work environment from the administrative perspective, any director, any chief ALJ, at any time during my career. I was, however,
shocked and dismayed by the backlash from colleagues after, after the lead workers and after more reductions were made in the work at home guidelines.
What's that mean?
There was a shutting off of communication, rude, condescending.
By whom?
I'm not comfortable saying that.
Well, you're under oath, and I'm asking the question, so I suggest you say it.
I'd rather not. It's nothing I filed a complaint about. I have no intention of doing that, and this is in-house. But I was dismayed that there was that reaction to the appointment of lead workers and the things that we were trying to accomplish. It was disappointing.
Okay. Well, that is an unbiased opinion based upon no facts at all for the committee to judge whether there's any validity to anything you're saying based upon the fact that you won't answer the question about who it is that you're referring to.
I will let our supervisor handle everything, and I haven't made a formal complaint, nor do I intend to. And so I don't feel comfortable giving a name or names right now.
Okay.
Certainly. And believe me, my politics swing more towards or away from the current administration than they do for.
Yeah, I'm not interested in your politics. Judge Hillary?
We have an accountable workplace now, which is different than what we had prior to June or July of 2013. And what that means is the judges are being held accountable for how you hold the hearing, how you write the decision, how quickly you get that accomplished. And some of the judges want to do that from home. I will say this, I think every one of our colleagues wants to do the best possible job they can. I think they have good intentions. But I think working at home for 10 years or more for most of them has left them isolated with understanding what issues are faced by even the clerical staff in our agency. So what has happened is the judges were asked to integrate back into the agency to provide more of a voice, to work actually in the office next door to some of the clerical staff. They resisted that. I can't say as I blame them. I understand that many of them enjoy that privilege of working at home. But what's happened is they've become so angry about being called to actually just physically work in the office like almost everybody else in our agency does, is that they've become bitter and irritated about that. We don't have a hostile work environment, we have an accountable work environment now, I would say. I want to go further with that, and I wanted to address your...
I'm interested in your statement about the anger.
Yeah.
How is the ALJ's expressed anger in a way that has become known to you as a lead worker?
Well, one of the judges walked into my office and said, "What is this touchy-feely?" And I don't want to repeat that word, about what was, I believe, the director asking them to be accountable to people who make complaints about how hearings are conducted. We have now, just as recently, we have an ALJ board in our ALJ room, and someone has hung up a little article in there about conduct and highlighted things about employees who are liars. It's just, it really boils down to this. The judges aren't happy that they have to come back and work in the office, and so they are upset about that, and I believe acting out about that.
Okay. Judge Lewis, have you ever tape recorded coworkers?
No.
No.
Not unless they're involved in observing the hearing with me.
But outside of that, you've never secretly paid coworkers?
No,
Okay,
I don't operate like that.
okay. Judge Hillary, are you aware of any civil rights complaints filed against anyone in the unemployment?
I am, but and they're still pending, so I don't know if I'm allowed to talk about them or not. I'm happy to answer your questions, but.
You can speak about them, just not in terms of identifying the parties involved.
I think there have been complaints filed, but merely because a complaint is filed doesn't mean it's justified. I do not believe any employee has had their civil rights violated by anybody in identity.
Okay.
I know of.
Okay, but there are pending,
I don't even know if bar is the right word. I know of one pending complaint.
okay. There was a hearing that you conducted on June 3rd of 2014, Judge Hillary. During the hearing, the administrative law judge, this comes from the Employment Appeals Board, related to your conduct. Are you familiar with that issue?
Can you tell me the name of the case?
I cannot tell you the name of the case at the moment.
The problem would be, I'm sure I conducted more than one hearing on that day, so.
The case was remanded for a new hearing.
Right, and I know that's happened to myself and to other judges. I know for further development of the record, I would say I have not always held a perfect hearing. I'm glad we have that remand ability from the Employment Appeal Board, so that in order for every party to feel like they have an opportunity to be heard, that we can have that remand fixed.
I'd like to read to you just what they found. A hearing in the above matter was held June 3rd, 2014. During the hearing, the administrative law judge regularly interrupted each party as the party attempted to set forth their case. She also rushed through questioning and oftentimes abruptly interjected or rephrasing the questions posed by the parties throughout the hearing. At times, the administrative law judge was dismissive and curt. The administrative law judge's decision was issued June 16, 2014, which denied benefits. The administrative law judge's decision has been appealed to the Employment Appeals Board. The Employment Appeals Board concludes that the record as it stands is insufficient for the board to issue a decision on the merits of the case, as the Iowa Court of Appeals noted in Baker versus Employment Appeals Board. The administrative law judge has a heightened duty to develop the record from available evidence and testimony given the administrative law judge's presumed expertise. The administrative law judge displayed an intimidating tone throughout the hearing. She inappropriately interjected herself into the hearing to the extent that she created what we conclude to be an unfair hearing based on the record. The board must remand the matter for a new hearing so as to allow the parties to avail themselves due process rights. Not very complimentary about your presiding over that hearing, is it?
I would say not.
Yeah. Would you say that that is a pattern?
I would not.
That is not a pattern.
No.
That's an exception to how you conduct yourself.
I would certainly hope so.
I would certainly hope so too, from one of our lead judges. Again, noting that most of the people that come before you are unrepresented and are certainly what I would consider novices in public hearings, and so probably not skilled or adept to challenge that kind of curt and dismissive attitude. You know, I think that when we talk about whatever issues relate to hostility in the workplace and how people are perceiving the workplace, I think that culture changes occur, and there was certainly a change in leadership and some revising of things, but to place all this based upon the decision to not allow ALJs to work at home seems far-fetched to me. It seems like, you know, we're dealing with adults here. I mean, we ought to be able to, you know, discuss those differences in a way that's productive. It doesn't make sense to me that we're placing all of this unhappiness in the workforce. I think we're going to hear from some ALJs that have some things to express today. But it seems far-fetched to me that these are all lawyers and professionals that are bringing these complaints forward, and as lead workers, you're saying, well, it's, you know, it's because we're making them accountable and they have to come to the office, and that's it. So I will be interested to hear more from the ALJs that bring their cases. I'm especially noting that, for the record, neither one of you have identified the ALJs that created problems or that you had issues with. And so I'll be interested to hear whether those ALJs will name names. So, because otherwise this is just really an exercise in futility. So, with that, I concludes my question.
Yeah, sorry, I dropped the ball there. I intended to question both of you. I thought we were starting with Judge Lewis, then we would go to Judge Heller, so I guess I didn't realize that we should question both of you at once. So I apologize for that. Judge Hillary, I think you told us, but how long have you worked as an ALJ for workforce development?
I started off as an attorney for the labor commissioner in 1987, 88, and I moved to become a deputy work comp commissioner in 1994. And in 2001, I became an unemployment appeals judge in workforce development in Iowa. So since 1994, I've worked in a capacity as an administrative law judge in one fashion or another.
Okay, so you've seen a lot of directors and lots happen during your career there. I would like to ask you some of the questions that Judge Lewis referred over to you. What are the standards that the federal government has for the timely deciding of these appeals?
We have 4 metrics that we have to meet. The first one is that 60% of our cases have to be decided within 30 days of the time that the appeal is filed. The second one would be that within 45 days of the time that the appeal was filed, we have to have 80 or 85% of those cases decided. As far as quality review, we have to have at least 85% has to meet the quality review of how that hearing is held. And then additionally, we have a case aging standard that requires that the average age of our cases be no greater than 30 days. And all this information is public. It's on the website maintained by the Department of Labor. And not meeting those metrics means we are not meeting the basic minimums that the DOL sets out for us.
Okay, now my question is, over your career, have there been periods of time when the department was not meeting those minimum standards?
There have been, yes.
And what would roughly the period of time have been where you didn't meet the minimum standards?
It really started roughly in the fall of 2009 and continued with on and off with no consistent meeting of those standards until October of 2013. I think you asked Judge Lewis earlier about if we're now meeting those standards. Yeah. I'm happy to say as a unit, we are meeting those standards since October of 2013. Both the 30-day metric and the 45-day metric, as well as the case aging and the quality review standards.
Now, are there sanctions if you don't meet those minimum standards?
Well, it can affect funding, and I know that the director will be here to testify for you all later on, maybe today, I'm not sure what day she's going to testify. But yes, it absolutely can affect our funding, and what that means is that when we in Iowa don't do as good a job as those in our other region, that means we get less of that help of the money in the bucket that comes to the state in order to administer our program.
And do you know if the state did lose some funding because of the failure to meet minimum standards?
I do not know that, but I know that the director has mentioned it, and it's a possibility, so I think that'd be a great question for her.
All right. Now, you said that since October of 2013, that you've been current.
Correct.
When was it that Director Waller took over the administration, or I don't know what the term is, but
She became our direct inline supervisor in July of 2013.
okay.
And one of her goals was that we meet those DOL metrics and that we do it as soon as possible so that it would have the least amount of impact, not just on funding, but on the parties. The director had indicated to all of us that she had been receiving complaints in the field, not only on the quality of the hearings that were held, but on sometimes on the timeliness issues that were held. And I think you asked Judge Lewis earlier about overpayment, about the issues about how the timeliness to get that decision. You have to remember too, some of those awarded benefits, and then they're later on an appeal level, those benefits are taken away from them. They get an overpayment that they eventually have to pay back to the government. So the longer it takes that judge to write the decision from the time of the hearing, the overpayment can continue to grow. So that has a huge impact, that timeliness standard, on the people, what they have to pay back. Or we have situations where employers say, we awarded benefits to this person. We have not yet heard whether they won or lost in the case, but yet we've gotten our statement of charges now, and our account is being charged for that, and we don't even know yet whether we've won or we've lost that case. So there's those timeliness, they have impacts not just on DOL, but on day-to-day life for both claimants and employers.
Is it fair for us to conclude that there's a correlation between the reduction of time working at home and the ability to meet the minimum standards that the federal government sets out that we were not meeting before? Do you see a correlation?
There have always been judges that have met the timeline standards. There's been a group of judges who've always met those timeline standards, and there's been a group of judges who've always struggled to meet those timeline standards. I think that for me, when I look at the judges who are now meeting those standards that struggled before, I do think my conclusion is that yes, it's because they are working more consistently in the office, and I think they now understand that meeting those DOL metrics is important. I don't know that those judges understood about meeting those DOL metrics, how important it was prior to probably July of 2013 when it became emphasized for all of us.
Do you know if there were any sanctions or any guidance or direction given to the judges that were not meeting the minimum standards to try to let them know they weren't meeting the minimums and they needed to be improved? Do you know if that was done?
I was not the supervisor, but I do know this, that I moved back to the office in October of 2012, and the clerical staff were upset because they were taking calls every day from upset parties wondering, where's my decision? Where's my decision? Where's my decision? So in order to help them, we created a late call log. That late call log meant that an email went to that judge saying, this person is called asking where is their decision. In addition to that, it went to the supervisor at that time, Joe Walsh. I know that from about October until July 2013, there were over 1,000 emails about late calls on decisions. Those would have gone to the judges. What they did or did not do with them, I do not know. What Joe Walsh did or did not do with those, I do not know. But I know that by August of 2013, the clerical staff were telling me personally, so much better now, because we don't have to take those late calls from people crying that they want their decision, or the employer wants to know what's happening on their case. To the point where we get no late calls anymore, so we don't even use the late call law anymore because there's nothing to keep track of additionally.
Do you have knowledge of the average caseload for one of these judges? What would be an average? Let's say now, and then if you can, 2-3 years ago, or whatever, you said this period of time when things kind of tanked was 2009. Can you give us some figures on the average caseload of the judges?
I know that Joe Walsh sent out an email in June 2013 where he indicated that he was going to take each judge's caseload to 30 per week or 30 hours per week. We luckily got a brand new reporting system in October of 2013 called Clear the Air, which 17 other states were already using ahead of us to record their hearings. That system gave us an ability to see how much time our judges were actually spending in the hearing. So when you know that you have 30 hours of hearing per week, it doesn't mean as a judge you're spending all that time in the hearing. You're spending time, in addition to that, working on the decisions themselves. We did some preliminary reviews, and we discovered that our judges were spending about 15 hours per week in the actual hearing time themselves. Then they had an opportunity to use the rest of what would be their 40-hour work week to get those decisions written. Now, in our region, we reached out to our DOL person to say, how many cases are others in states like us, in our region in the Midwest, hearing? We discovered that Iowa is right in line with what others are hearing. In Illinois, I think here's more. We discovered we're paid better than most of our colleagues in other states. We don't have any greater hearing load than they necessarily do. But what we did start to do is meet those DOL metrics in our region. Did I answer your question?
Well, I'm not entirely clear. You said we're similar to other states. Now, is that now, or is that during this whole period of time? In other words, have things changed now? Are the judges deciding to handle more cases now than they did 2 or 3 years ago, say?
No. And in fact, our caseload, we dropped from 30 hours of hearings per week down to 29 because we've caught up and we're staying current on our caseload. Now, you do have to remember this. In 2008, 2009, when the economy tanked, we had many more appeals than we do now. To the point where some of our judges volunteered, myself included, to work on Saturdays, to actually hear a single party cases on Saturdays. But there's no judge has ever been required to hear 40 hours of hearings per week. I would say right now we are very comparable to what other states are requiring their administrative law judges to do.
So it's always been roughly 30 hours a week over the years. Is that what you're saying?
When we
When we were behind, it was 30 hours a week roughly.
Yes. But I will say this too, before 2008, there were even weeks when we did not have 30 hours of hearing per week for each judge because the economy was so good, there were so few claims, there just weren't physically that many cases. I think most judges never heard cases on Fridays prior to 2008 because we just did not have the cases to put in those slots.
Now, does 30 hours a week mean 30 cases a week?
It can mean, you have to have 30 hours of time to do a scheduled hearing. It can usually be more because there's a couple of little extra cases that, like companion cases that go along. If you have a case where someone's been awarded benefits, you may have an overpayment case that goes along with that. So it's 30 hours of hearings, 30 hours during your 40-hour work week that you have to have available to hold hearings in. Sometimes you'll get more cases in there, sometimes a little less, but it should average out for each judge over the course of a year.
And that's consistent with the federal standards?
It is, and it's consistent with all of the other states in our Midwest region, what they do, what they expect, what they require for their administrative law judges.
I'm a little puzzled by, you can probably explain this, but you said that we were substantially behind, late, we weren't meeting the federal standards in getting cases decided. Over the years, I'm puzzled. Tell me how that relates to the fact that the judges had scheduled 30 hours a week of hearings.
Well, there are times when the economy was bad that we had 18,000 appeals in one calendar year. Then in another calendar year, if you have 12,000 appeals, you're obviously going to have a tougher time keeping up. But, I mean, so sometimes there's just so much work that it can't all necessarily be done. Sometimes it's that the judges just aren't getting the work done in a timely manner. They're hearing cases and it's taking them months to get that decision out the door, or weeks to get that decision out the door.
So it wasn't the fact that they didn't hear 30 cases a week, it was the fact that they didn't make their decisions in a timely manner. Is that the point?
That's the point.
Okay. Okay. And it wasn't until a year ago or so that you actually got caught up.
Correct.
You know what our current ranking is as far as timeliness in comparison to the other 50 states?
They do not rank us. The Department of Labor doesn't rank us specifically, but right now our most recent indicates that we are about in the mid-range of the states, about halfway point through 24. I know that if you look at us, prior to the time we got up, we were 47 in the nation.
47 out of 50?
Correct. Well, I think 51 or 52. Puerto Rico passed.
Okay.
Yes.
So now we've moved up, so we're about average as far as now. Okay. Let me ask you too about the tip sheets. We've heard a lot about that, and Judge Lewis talked about it. But give us your take on tip sheets, what they are, why we have them.
It's information for the public. It's in the form of frequently asked questions. I know that as far back as 2007, when Dan Anderson, the Chief Administrative Law Judge, his outline on the law appeared on the agency website as, here's the basics of unemployment law. It's a resource for anybody who wants to go on the website and use it. And I would like to answer a question that I haven't been yet asked. I have never been pressured to decide a case any particular way by any chief administrative law judge, by any director, by any management person, or anyone in my entire career at IWD.
These tip sheets that you're talking about, I guess we've heard they're available to anybody, public employer, employee, anybody else wants to look at them.
Anybody, and they deal with basic issues like unexcused absenteeism or discharge for misconduct. What does that mean? Anything about the unemployment law from what a party may need to know.
So that would give either party a little primer on what the rules and regulations are, would help either side comply with the rules and make the best case that they can make, and it sounds like.
Absolutely. You have to remember too, the tip sheets are not written from any perspective other than this is what the law requires. It's not written so that claiming, here's how you can get your unemployment benefits, or employer, here's how you can avoid paying unemployment benefits. They're not written from that perspective for anybody. They're merely, here's what the law requires, here's what the standards are, here's the information you need.
Do you have knowledge of the percentage of decisions that have been in favor of the employer as opposed to the employee over the period of time we're talking about here?
There's a DOL report called 5130 that all of the information that we have gets entered into a computer that is supplied by the Department of Labor, and they collect that information. No one in the UI appeals unit has ever used the information to decide if you rule in front of a claimant, or for a claimant, or for an employer to make any type of decision. I don't regularly see that information on a monthly basis. And also, I do not know what the Department of Labor does with that. I know that at one time we had made some changes to how we were coding things, and evidently it was problematic there, but if that report exists, it goes to the feds.
Okay, so there'd be a report that would tell the outcome of the case and decision.
There is.
Okay.
There absolutely is that report, yes.
All right. Can you tell us about federal requirements for working at home? Are there certain requirements that you're supposed to follow if you're going to do that?
Well, I don't know if there are federal requirements. I believe that and I do not have a work at home contract currently. That if you're going to work at home, I think DAS has requirements that they want individuals to sign off on a contract so that they can know that state equipment is going to be safeguarded, that you're going to be working in a safe environment, that as far as the feds asking us to have that, I don't know if that's the case or not, and I do not have a contract myself.
Okay. Do you know if the ALJs over the years that were working at home was spending a substantial amount of time at home, apparently from what we've heard here, did they have written agreements under that policy, whether it's federal or state? Did they have written agreements?
I worked at home myself for about 10 years, and until, I want to say 2011 or even 12, I don't even think we were presented with a contract that we had to agree to sign in order to maintain the privilege of working at home. So for the majority of the time I worked at home, I was never asked to sign a contract or work at home agreement at any time.
Were you given instructions as to what was expected of you in terms of hours or output, and how many cases you were expected? Were there any guidelines or instructions given to you as to what was expected of you if you were working at home?
Prior, not that I recall, prior to the work agreement, I mean, every judge knows when you hear the case, you have to write the decision. And you're given an itinerary every week that tells you the due date for that decision to meet the 30-day metric. Now, sometimes if you're not scheduled to the point where you can meet that, if the 30-day metric date has passed by the time you've heard the case, obviously you can't meet it. But as far as any specific instructions that you have to do this, if you don't meet this expectation, you'll be called back to the office. I was never done that.
So even though the state was way behind and not meeting the minimum federal standards, as far as you know, there wasn't any action or instruction from the top administrator saying, hey, folks, we're way behind here. We're not getting the job done. You got to step it up. You never got any of that at all. That's what you're saying?
I don't think some of the judges understood how bad it was, how much we were failing to meet the metrics.
They weren't even told by I forget the title, the administrator or the people in charge. They weren't even told that you're way behind.
I believe that's correct, yes.
When was it that Joe Walsh left the department?
July of 2013.
And he was put in charge of the ALJs at when?
January of 2011.
So, there were about 2.5 years where he was the head guy.
Correct.
Who did he replace?
Dan Anderson.
And what happened to him when Mr. Walsh took over?
He stepped down and became an administrative law judge. He was the former chief, and he continued to work just as an administrative law judge and no longer the chief.
All right. Do you know if he had any administrative duties during that time, or was he just purely deciding cases?
I think he kept up reports, but I don't know exactly what he did. At that time, I was also working at home.
Yeah. But your understanding is he did some of the administrative work
Yes.
that he had been doing in the past, and so he helped out, I guess you could say, helped out Mr. Walsh with some of the duties of what is it, the title of the administrator?
She is at a title at the time as chief administrative law judge.
Chief administrator, okay. All right. Was at that time, when he was chief judge, did you have issues in the agency of, I'm hesitating to say hostile work environment, as the term has been overused, probably a little strong, but was there dissension or, I don't know, bad feelings in the agency during that time?
When Dan Anderson was the chief ALJ. When you say he, do you mean Joe Walsh?
Yes.
When Joe Walsh was the chief?
Yes.
Not that I recall.
Okay. All right.
I do want to point out, I don't think Joe Walsh always treated me particularly fairly,
But he what?
he did not always treat me particularly fairly, but I would.
What do you mean when you say that?
Well, I think once he found out that I was providing accurate information to the director of the department, he wrote me up.
What does that mean, he wrote you up?
For gossiping.
So what, kind of a reprimand? What do you mean?
Well, it's not considered disciplinary, but he sent it to me over the weekend, so that I got it Monday morning on June 10th when I came into the office.
And it was, if reprimand isn't the right word, it was critical of you for what?
Gossiping is what he said.
And what did he mean by gossiping?
I don't know, I can never find that out from him.
Did you ask him?
Absolutely. Via email and then with a conference that same day with the human resources person in our office, John Russell.
And what did he say when you asked him what he meant by that?
He didn't want to discuss it. I knew what he meant. He wouldn't discuss it. And it wasn't disciplinary, so it's not considered part of my disciplinary record, and that was it.
He told you that you know what I mean.
Exactly.
Okay. That's all I have.
This question is for both of you. Did anyone in the department help you prepare for today's hearings?
No.
Have you ever been asked within your department to speak to legislators about work happening in the department?
No, never.
And does your director ever work from home?
I have no idea.
I don't know. All right, thank you both for being here today. I don't believe we have any more questions for you. Our next person that is coming to testify is the former chief ALJ, Joseph Walsh, who currently is the Deputy Workers' Compensation Commissioner. You're getting set up here.
I do have a written statement for you if you want me to pass those.
Great, that would be great. John, I'm not sure if you have been here, but we will have Deb issue the oath before we get started.
I'm sorry, I just made 5. I passed 5 of those down because then I asked them to come.
Could you raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Do you have an opening statement for the committee?
I do, and I apologize. It may be a little bit longer than some of the other ones you've heard, but I'd like to get a few things out in the open here today. My name is Joe Walsh. I graduated from Drake Law School in 1996. I worked for a prestigious labor law firm in Des Moines, Iowa. I eventually became a partner and had a successful legal career. In 2007, Governor Culver asked me to serve as the Deputy Director at Iowa Workforce Development, and I agreed. This was a political position. I served at the pleasure of the governor. In 2010, I agreed to serve as the Chief Administrative Law Judge for Iowa Workforce Development. I was hired through the merit process. I served in that position until I was relieved of my duties in July of 2013. In January 2011, Teresa Whaler became the director at Iowa Workforce Development. I was excited about working with her. I had been a lifelong Democrat, but I had spent the previous 3.5 years of my career learning how to bridge gaps in partisanship and solve real workforce problems, and I saw this as an opportunity. I presumed, without even thinking about it, that she intended to respect the administrative judicial process. Judicial integrity is not and should never be a partisan issue. The job of the Appeals Bureau is to resolve disputes involving unemployment benefits. A judge's job is to hold a fair hearing, ascertain the facts, and apply the facts to the law. My relationship with Teresa Whaler was generally professional in the beginning. She told me she was happy to have me on staff. From the time of our very first meeting, it was apparent that she harbored a notable bias in favor of employers over unemployed Iowans. For nearly 2 years, however, I was able to redirect her efforts to insert her bias into the judicial process. I've spent a great deal of time educating her about the process and specifically her role in it. I insisted on an agency tone of judicial integrity and independence. While I sensed resistance from her to the idea of independence of the Appeals Bureau, we reached an understanding that really did work for about 2 years, in part because of my constant efforts to protect her. I am prepared to go into detail today about the ways in which I feel Director Whaler ultimately attempted to interfere with the administrative judicial process at Iowa Workforce Development, and I presume that those are what most of your questions are going to be about today. I would like to make 2 points initially here so that you understand the context of how we were viewing things, particularly in 2012 and 2013. First, everything that occurred in the Appeals Bureau in 2012 and 2013 occurred under the backdrop of what Governor Branstad had done to Commissioner Godfrey. The Division of Workers' Compensation is in our building at 1000 East Grand. I knew, all of the judges knew that Governor Branstad had demanded Commissioner Godfrey resign. We knew he threatened to cut his pay if he did not resign. We knew that he ultimately did cut his pay and vetoed funding for his agency. We all knew that Governor Branstad had stated the reason he did this to Commissioner Godfrey was because he was not pro-business enough. We all witnessed this firsthand. Second, I think it's critical to understand the context of this, understanding Teresa Whaler's leadership style. I witnessed it firsthand as a member of her leadership team. She is calculated, and her primary leadership tool is fear. She sends messages to her staff and others to scare them into doing what she wants. In my experience, her messages always had a purpose. With this context in mind, these are the types of activities that she engaged in which I felt crossed the line and encroached upon her judicial integrity.
She instructed me to write and have staff prepare employer tip sheets, which to her were essentially legal advice for employers to avoid paying unemployment insurance benefits, a how-to. She attempted to compel policy interpretations of the law upon judges under the guise of obtaining uniformity. In my experience, this was always designed to make legal interpretations more employer-friendly. She ordered me, against my advice, to poll the judges about their understanding of a point of law which she did not feel was fair to employers. And she instructed me to gather data on the judges to determine which judges were more likely to rule in favor of employers. With all of this, she refused to follow my advice and utilize her legitimate powers of rulemaking and proposal of legislation. I think those things were more open than she wanted to be in her strategy. With many of these actions, I believe she was trying to send messages, sometimes subtle, sometimes not, to the judges and myself, that we were granting benefits too often or that she was dissatisfied with judicial outcomes. Again, these incidents occurred over a period of time, and I want to emphasize that initially, early on, I was able to redirect many of her attempts in this regard. By late 2012 and early 2013, they become much more forceful and aggressive. Throughout all of this, the judges were watching what was happening as much as I attempted to be a buffer between the judges and the director. By 2013, I was regularly approached by judges who were concerned about their judicial independence. These issues all came to a head in the spring of 2013. At that time, the director had elicited the assistance of one of my subordinates under my leadership in the unit. That was Teresa Hillary, who you just heard from. As I mentioned earlier, when I was hired, the position of Chief ALJ was a merit position. Merit status simply means that a supervisor must have a good reason for removing a person. They cannot be fired for political reasons or for no reason at all. It does not mean that there is no accountability. A merit employee can still be removed for a good reason, although there is supposed to be due process before that occurs. In April 2013, Director Whaler notified me of her intent to change my employment status from merit to at-will. The status change was part of the branch administration's larger plan to have fewer merit employees on the state payroll. This, however, in the context of unemployment appeals law, is a violation of well-established legal principles. I immediately went to IWD Human Resources Manager John Nelson and I explained the problem to him. John Nelson agreed there was a problem. He agreed to place the action on hold and to fix it. Instead of fixing it, however, Director Whaler ignored it. She ignored the HR manager's promise to place the matter on hold and officially classified me as non-merit in May 2013. At that point, I contacted the United States Department of Labor and I explained the situation to them. I then confronted Teresa Whaler, who told me her initial response was that her lawyer from the Department of Administrative Services, Ryan Lamb, had made the decision that I should be non-merit. I met with Lamb. He denied this assertion. He told me he merely gave her a legal opinion, which was based on her statement to him that my job was mostly managerial. There is actually no such exception for mostly managerial judges under DOL guidelines, but the characterization was not true in any event. Mr. Lamb agreed to contact the U.S. Department of Labor himself. When he did, he was told the same thing I was. Judges who hear cases must have merit protection under federal law. Within a few days of Lamb confirming this, Director Whaler called me into her office and told me she was stripping me of my authority to hear cases. This was obviously unprecedented. I went to the U.S. Department of Labor, the Iowa Workforce Development Board, the governor's office to fight this. To date, I have never heard from the governor's office. Toward the end of June 2013, Director Whaler reversed her decision to make my position at will without giving me any explanation at all. I believe the U.S. Department of Labor instructed her their actions were illegal and inappropriate. Approximately 3 weeks later, on July 15th, without any notice, she laid me off and had me removed from the building. She laid off my wife on the same day. My wife had worked for the agency long before I did and had run a number of programs and grants. Her position was fully funded, as was mine. In fact, I had repeatedly been told by our financial management division that my budget was set to be $250,000 under budget for fiscal year 2014.
Since I was removed from my position, Director Whaler, it's my understanding has taken over the management of the Appeals Bureau herself, which means that you have a partisan political appointee in charge of the direct management of administrative law judges. This is something I never thought I would see at IWD. I was active in the national group, and I'm not aware of any other state that has this type of a setup. I believe it inherently violates the fundamental tenets of judicial independence. I think it places both her and the entire Bureau in a bad position with a built-in appearance of impropriety and conflict. Since my layoff, Director Whaler and officials from DAS have continued to interfere with my career. In January 2014, I attempted to become reinstated at IWD through the outplacement program in the Division of Workers' Comp. Since January 2014, I have been back then Deputy Workers' Comp Commissioner. In January, however, the director wrote to Commissioner Godfrey and told him I should not be reinstated because I had filed a complaint that was pending before the Public Employment Relations Board. Commissioner Godfrey followed the outplacement policy in any event and reinstated me. He reinstated me because I am highly qualified and earned the position based upon the merit rules. In April of this year, I filed a lawsuit against the state of Iowa based upon Teresa Whaler's actions. Her response was to issue a press release under Iowa Workforce Development letterhead, attacking my work performance and insinuating that I am dishonest. She said that my lawsuit was frivolous. According to the Des Moines Register, she did all of this contrary to the advice of the Attorney General's office. I feel compelled to take just a moment to defend myself from that unprecedented attack. In that press release, she alleged for the first time ever that I was laid off for performance reasons. If this is true, this means that her layoff plan, which she submitted to the Department of Administrative Services, was false. In the layoff plan, the only reason she listed for my layoff was budgetary. In any event, I was never told at any time that my performance was an issue prior to my layoff, which is required by law under merit rules. And I have never received a does not meet expectations in any employment evaluation. I'm looking forward to answering questions about the performance of the Bureau. My performance, in fact, was excellent. When I took over the Bureau, we were under a performance plan from the U.S. Department of Labor due to one of the worst recessions in U.S. history. In 2010 and 2011, we had record numbers of appeals and decisions. Now, we've talked about this 30-day standard. The United States Department of Labor sets a primary performance standard for timeliness that the Bureau must issue decisions within 30 days or less for 60% of our cases. When I took over appeals, we were issuing less than 10% of the cases in 30 days or less. By the end of the first year, despite record numbers of appeals and decisions, we were regularly meeting the 30-day standards on a month-by-month basis. There was definitely still room for improvement, but we had made tremendous strides in the first year. Our efficiency metrics, however, were more important to the director, so that is what I focused on. These are a different set of standards completely. While other divisions in the agency were lagging in efficiency performance, the Appeals Bureau had moved from 36th in the nation to 18th in case processing efficiency from 2011 to 2013, the time I was there. In 2013, in fact, Appeals was the only unemployment insurance funded unit in the entire agency which was moving in the right direction in terms of MPU, minutes per unit efficiency. In addition, in 2012, I received an unambiguously successful review from the U.S. Department of Labor. We met U.S. Department of Labor quality standards in every quarter, and I provided my staff with direct, regular communication regarding their performance. In that press release, she made a number of other misleading attacks against me, which are really nothing more than an attempt to damage my reputation, otherwise retaliate against me for blowing the whistle on her improper conduct. My fear coming forward here today is that it will incite more attacks or retaliation from her, and not just against myself, but against any of the other workforce development staff who are stepping forward. But because I feel so strongly that she has damaged and is continuing to damage the integrity of our administrative judiciary, I feel I have no choice but to come forward and speak. The truth is, I was not fired for performance and I was not laid off for budget reasons. I was reorganized out of my job because I stood up to her. Canon 1 of the Code of Administrative Judicial Conduct states that a presiding officer shall uphold the integrity and independence of the administrative judiciary.
An independent and honorable administrative judiciary is indispensable to justice in society. I have devoted my career to the concept that every person deserves a fair fighting chance in our justice system. Whether you're the CEO of a powerful, wealthy corporation or a frontline worker in the dirtiest, lowest paid job in the state. To me, this is not some abstract principle or philosophical ideal. It is the fundamental working reality of the rule of law. Having a fair, unbiased system for resolving disputes is essential to stability in our society, and it is what decent people strive for regardless of political leanings. When people file for unemployment benefits, they are often at the very lowest point in their life. Those people, their families, and their communities who rely on those benefits, they deserve better than this. They deserve a fair system. With this in mind, I do have two recommendations I want to make to the committee today. My first recommendation is that you pass legislation which requires judges to be free of pressure, subtle pressure and direct pressure from political operatives in the executive branch. Every judge, including managing judges, should be merit employees. If this cannot be done, I think administrative law judges should be moved to the judicial branch. Second, I urge you to appoint independent counsel to fully review all of the branch administration's uses of the administrative judiciary. I think this has to be removed from politics in the political system and be reviewed independently, and I fear that unless we do this, there's never going to be any true accountability. I'm willing to take whatever questions you have.
Thank you for being here today. Senator King.
Thank you, Judge Wall. You covered a lot of information there. And thank you for coming in today. This is never easy. So, from my aspect, can you quickly explain to me how the unemployment compensation process and appeals and the system is supposed to work?
So, just as in a nutshell, kind of unemployment process 101. A worker who is separated from employment can file a claim. The employer then has an opportunity to protest that claim, and if there's a dispute, it would go to fact-finding. Either party has the right to appeal a fact-finding decision, and that's when it goes to the appeals bureau, and that's when a real hearing is held as opposed to a fact-finding interview. And that's what the appeals bureau does at Iowa Workforce Development. It resolves any disputes which occur in that fact-finding process.
And then based on the truth or the validity of the fact-finding, you issue your opinion based on that fact-finding.
In the appeals unit holds the judge at that point holds a fair hearing, usually by telephone, but they can request in-person hearings as well. And the judge will then ascertain all of the facts that are relevant to the issue that's involved in the case, and then interpret the law and apply those facts to the law.
So what then were your duties as the chief ALJ?
The chief administrative law judge, I ran the appeals bureau. That involved both hearing cases, that involved managing the unit, managing all the personnel and processes in the unit.
Okay. So when your position went from at will to confidential, what did that mean as far as your job?
When the director notified me that my position was being changed from merit to at will, she made no other changes in my job description or anything else. My job description stayed exactly the same. She just would have had the power to fire me for a good reason, a bad reason, or no reason at all.
Okay. So do you have any documents or correspondence between you and the Department of Labor Director Walter Government Office regarding your status and your status?
Yes, I have 5 copies of a set of documents that support a number of the facts that I have brought up here today that I'll pass down. I'm happy to go through with you what those documents are.
Kind of a Reader's Digest version of what the point of this is.
The first document is the layoff plan, which was submitted by Director Whaler to the Department of Administrative Services, which shows quite clearly that the only reason that was listed for my layoff, she's required whenever there's a layoff done to submit a layoff plan to DAS and give all the reasons why the layoff was done. This indicates that the layoff was due to lack of funds.
And at the time, there were no lack of funds.
Well, just so, no, not in my budget. My appeals budget, we were $250,000 under for fiscal year 14. There is an argument, at least, that that unemployment funds overall had been reduced, and that cuts were needed to be made. Unemployment funds from the Department of Labor go to several different divisions and units within the agency. Ordinarily, if that occurred, I get something from financial management saying you need to cut more, you need to do something else to make sure, but I had made sure our budget was well under budget because I was worried about layoffs for staff, actually. The second page is the April 5th, the third page. The second page was just an attachment, I believe, to the layoff plan. The third page has a 2 in the bottom right corner. Is an April 5th, 2013 letter from Teresa Whaler to me where she attempted to make where she announced to me that she was going to make my position at will. The next document has a 4 in the bottom corner. That's my email exchange with Ryan Lamb and the documentation of our conversation after the director had told me that Ryan Lamb had made the decision to make me at will. This is the documentation of my conversations with Mr. Lamb. The next one has a 3 in the bottom right-hand corner, and that's an email exchange that I had with Director Whaler. After I learned that she was not going to honor John Nelson's promise to me that he was going to fix the problem and place the letter on hold, I confronted her in this email and went to her office immediately after this, and this documents my conversations with her, where I also tell her very clearly in no uncertain terms that this is a violation of federal law. The next document, the next overall document, is what's called a PDQ. It's a position description questionnaire. It's basically just a job description. This was the new job description that she prepared for me after she stripped me of my authority to hear cases in June 2013.
And what was this new job title?
The new job title was the same. It was still Administrative Law Judge 3, and I was still going to be called the Chief Administrative Law Judge, but it just took away all of my authority to hear cases.
So what were you to do?
Simply be an administrator of the unit.
By that I mean, what would you be as an administrator you were assigned to do?
I would still carry out, there wasn't enough to do as an administrator, but I would manage the personnel, manage the processes, the workflow, and those types of things. So I would keep all of my regular duties. The only thing that was different is I was strict with decided cases. The next is an email, with a 6 in the bottom corner is an email exchange. This is when after I got the PDQ, after I got the job description, I had a meeting with Teresa Whaler. I told her I was not comfortable signing the new job description. This is when, on June 12, 2013, she told me that the new job description was in effect. Didn't matter whether I signed it or not. And this became a tense exchange, but this documents my efforts to explain to her why it was inappropriate to do what she was doing.
Did she have the authority to do that?
That's a legal question. I don't believe she did. I mean, she certainly
I don't know. So
she certainly has the legal authority to answer your question. She certainly has the legal authority to revise the job descriptions of people who work for her within the guidelines that are laid out by DAS. She certainly does not, under the U.S. Department of Labor standards, have the authority to retaliate against somebody for complaining to the Department of Labor, which is what she did.
Thank you for making that distinction.
After that exchange occurred, and she told me that I was already stripped of my duties and my authority to hear cases, I really fell back into a corner, and at that point, I went to the U.S. Department of Labor. This is the email that I sent to virtually everybody. It was actually addressed to the Iowa Workforce Development Board members. I copied it in the U.S. Department of Labor. I copied, I think, Jeff Point from the governor's office, where I laid out in pretty detailed fashion everything that occurred in the timeline of Director Wheeler's retaliatory actions against me. And that is an email exchange that goes on for about 5 pages.
What was the reaction from the administrator?
I heard nothing from her initially after she got that. One of the underlying issues that was still going on is she told me I was stripped of my authority to decide cases, but I in fact had several cases pending in front of me at that time. So this was a major shock. It was a major change in position for her to tell me. So we did get that resolved, and she eventually told me I could finish up the cases that I was working on, and we reached an agreement. But I never heard anything specifically. She never said anything specifically to me about that. On June 18th, then, I wrote to the Department of Administrative Services, and that's what the next email is, asking them, again, lay out the details of what had occurred, and asked them what my current status was. I didn't hear back from them, but then on June 20th, the last page, number 9 here, is where Director Wheeler backed down, and she restored my position to be a merit position at that time on June 20, 2013.
What happened after that?
After that was, everything was quiet for a while. And then on July 15th is when there was a mass layoff in the agency, and she had, at some point in time, just developed plans to include me in the mass layoff. So on July 15th, I was called into her office and then walked out the door.
During your time then as Chief Administrative Law Judge, how were cases assigned to ALJs?
In general, the cases are assigned randomly. We have a scheduling clerk. If there was any, I reviewed the logs every week. I reviewed the cases every week that were coming into the agency, at least glance at them. If it came to my attention that we had something that was high profile or significant legal issues or had a number of attorneys, it was going to be something complex, I would address those issues as the Chief Administrative Law Judge. But generally speaking, the cases were assigned randomly by the clerk.
So just the clerk. So that way there was no bias, everything was above board that way.
Exactly.
Okay. And then, did the director ever ask you to assign a particular case to a particular ALJ?
No. Again, especially for the first two years or so, we had established a pretty good relationship of judicial independence, and she would have known better than to come to me and try to assign a case. I would go to her at times and tell her, we have this case pending before the agency, it's in the news for other reasons, I want you to be aware of that out there, but never, no, she would have never come to me and told me to assign a case. She knows I wouldn't have allowed that.
And just for the benefit of everyone, why is it so important in our process that we maintain separation of powers and not have political appointees assign cases?
Well, I believe it creates an inherent conflict, and always, if a political appointee is assigning cases, they better have a really good reason for doing what they did. The reason for that is because it will give the appearance and shape confidence in the decision if it's done in a way that is even arguably biased toward one side or the other. And the fact is, it's always, when it's being done by a political appointee, signing to a specific judge, if that ever has occurred, that would look inherently biased.
So who is in charge of educating the director of the boundaries then between the ALJ and the department director?
The chief administrative law judges.
And the director's role, what is the director's role in knowing about a case versus direct involvement?
The director of the agency in these situations needs to have knowledge about what's going on in the unit. They don't, it's wrong because they get held accountable for it at some level. And so it would be wrong to say they shouldn't have any knowledge at all. The separation should be a very clear separation, that there's no influence over that decision in any way, shape, or form.
So did the director ever ask you for individual data on how the judge is ruling?
Yes.
Can you explain that?
Yes. It originally came up when there was controversy over the Division of Workers' Compensation, and there were folks who were trying to track the workers' compensation judges in their decision to determine how pro-employer, how pro-insurance company, or how pro-injured worker those judges were individually. And the director came to me and told me that she wanted the same type of data for the appeals judges. It was very controversial in workers' compensation, and so our initial conversation, I kind of got her off of that idea and said it's not a good idea. What would be the reason we would want that for? And she eventually just kind of dropped it. In 2013, she became very, very forceful in me gathering this type of information. And I finally I asked her what her reasons were, and she could not articulate anything to me other than that she would like to be able to see how many times a judge finds in favor of a unemployed Iowan compared to an employer.
So she asked you directly, I want to know numbers, how many times you settle for employers, and how many times you judge you settle for employees.
Yes.
And she asked you that directly.
Yes.
She wanted that information.
Yes.
And she never said what would be the use of that information.
No, again, she went into an explanation at one point, and she talked about, you'll have to ask her what she meant by this. She said something about the law of big numbers, and that she would expect, that there would be some consistency between the judges once you got a big enough sample size for this. But at the end of the day, what she was really telling me was she wanted to be able to compare which judges regularly rule in favor of employers compared to which judges regularly rule in favor of unemployed Iowans. That's how I interpreted it.
So then you would have a pretty good list or a pretty good track record from that who was ruling in what way. So does the department then, I think we heard previously, the Department of Labor takes this information, but it would be rather unusual for IWD to keep that information, correct?
No, let me explain that. One of your previous witnesses talked about the 5130 form.
Yes.
The 5130 form collects the data in aggregate, and it's important data that I would, as the chief administrative law judge, is a tool I would look at on a regular basis to gauge the overall performance of the unit. And what I used the data for was to determine if it looked like something was out of whack on an aggregate basis. What I believed was that it was not appropriate, without some really good, compelling reason, it was not appropriate to collect, or necessary, to collect that data by a specific judge. And I have some data on the 5130s that I have compiled as the chief administrative law judge, if you're interested in it.
Sure.
Yeah, I have 5 copies of this, but this data tends to lag a little bit, so we don't get real-time data as we do in some other areas, but and it's a little bit hard to follow this chart. I based it upon how the U.S. Department of Labor does their charts, and it's not real friendly. So when you're looking at this, at the very top it says year, and then it says appeals-CL, that's appeals claimant, that's an unemployed Iowan. Then it says appeals-employer, that's the employer's position. Then it says EAB, CL and EAB employer. That's the Employment Appeal Board, the same statistics for the Employment Appeal Board. So in the year 2011 then, there were 11,249 appeals filed by claimants. There were 6,112 appeals filed by employer. The reversal rate is the next number, 3,900 cases, 3,962 cases were reversed in favor of the claimant, that's 35.2%, compared to 2,525 cases reversed in favor of the employer, that's 41.3%. So you can see we had a slightly higher reversal rate in favor of employers over unemployed Iowans. And those numbers were actually fairly consistent from year to year. You would see some variation. I still have a couple questions about exactly which cases they included in that, because we actually had more than 17,361 cases in 2011. I think we were approaching actually more like 20,000 cases. Some of the one-party cases and so forth may not be included in those numbers. We were actually, when I got I mentioned in my opening statement, we had a Department of Labor review in 2012, which was a successful review for my leadership over the Appeals Bureau. In that meeting that I had with the Department of Labor officials, they actually told me that they were going to put a finding in, an adverse finding for the state, that we were reversing statistically significant percentage higher in favor of employers than we were for unemployed Iowans. I did have a conversation with the DOL official about that and tried to explain why, what I thought the reasons were that was occurring, and it never did end up in the final report.
So they were satisfied with your explanations at that time?
Yes.
Okay. Does the department then collect and aggregate data on judges? Is there technology being used to give the director individual data on police decisions?
I believe there is.
Can you explain that?
I believe that I had multiple conversations with several people from IT when I was being instructed to do this by the director, and got different answers there initially. It is my understanding that they have found a way to track it. I don't quite understand the IT solution that they came to, but it is my understanding that they do now use an IT program to track each individual judge. And how often they rule in favor of employers versus unemployed Iowans.
So this way it would show if a judge was showing favoritism to one side or the other. And you think this would be the purpose of that data?
I think, yeah, I can't speak to the purpose other than what the director had told me previously. I don't know what they want for, but that's what you could argue. I would argue it wouldn't show you that. Unless the numbers were really out of whack. There are instances where that information could be useful. For example, if you had a judge who, I think there was a story a few years ago about a Social Security judge who had been found to never rule against a claimant. He always ruled in favor of the claimant. The thing is, when I was managing the unit, I was reading decisions, I was reviewing the decisions that came back from the Employment Appeal Board, I was on top of that, so I would have known if we had an issue of any judge being out of whack. I was close enough to the situation that I already knew that.
And perhaps it might indicate that either they have a misinterpretation of the law or a policy or a ruling or a rule of some kind.
Correct.
Very good. Thank you.
Did the director ever express dissatisfaction with any of the decisions coming from the ALJs?
Yes. she came to me with numerous, I guess what I'd characterize them as constituent complaints through the years. Again, some of this is legitimate. The director, if somebody comes to the director and says, hey, what happened in this case? I mean, I went out and gave speeches, and the most common question that I ever got was, how did I possibly lose my case? And so the director's got to be able to respond to those. And she would come to me over time and ask me about decisions. Her tone, again, my very first meeting with her, with any substance, was about an unemployment case. And I explained, after she showed it to me, I went and researched it and came back to her and explained it, what had happened in it, and she was just disgusted. She thought it was a terrible miscarriage of justice, and this employer had been charged benefits, and that's when it became very apparent to me she had a notable pro-employer bias. Again, initially, I was able to develop some separation with her and be a good buffer, and she understood that she could only go so far with that. But what developed in it is she would come to me and she would be quite frustrated with the decision. She started asking me things like, who's the judge who decided this case? That's actually when she started demanding that I have the judges write employer tip sheets. Again, these were not, they're being called tip sheets now. When she told me to write these, when she told me to have these written, they were called employer tip sheets. And her plan for these tip sheets was to take them out to employer groups and have them be legal advice from administrative law judges on how to defeat an unemployment claim against your company. And I told her, I said, again, we can't do this. That's not the role. Judges do not give legal advice to employers or to unemployed Iowans. We decide cases, and the last thing I wanted was somebody walking into a hearing with one of these employer tip sheets and saying, hey, this employer tip sheet says right here, I did everything right. Why do I have to pay benefits? And so I actually tried to separate the Appeals Bureau from those tip sheets. Mike Wilkinson, the division administrator for unemployment insurance, was brought in, and I tried to get him and his staff to do most of the writing, or we would just sit back and kind of review it and make sure there's nothing completely wacky in it. What began happening is when the director found a decision that she was very dissatisfied with, she would come to me and say, go write a tip sheet, or go have this staff person write a tip sheet about this decision. And again, I mentioned earlier, the director doesn't do things frivolously. She had a purpose, she had a message when she came to me with those. And it may have been nuanced at times, but I clearly got her message.
Did she ever come to you on behalf of an unemployed Iowan, or was it always on behalf of an employer?
In 2.5 years, she never came to me on behalf of an unemployed Iowan. And I would just point out, I would just add one thing on this as well. I attempted to rename these from employer tip sheets to, and the name that I came up with was public guidance memos. When she would ask me about a tip sheet and doing a tip sheet, I would tell her, Appeals Bureau doesn't have anything to do with the tip sheets. We have these public guidance memos. She finally told me, she said, I hate that name, come up with a different name. And, but I'm the one who actually steered her away from calling these tip sheets, calling them employer tip sheets, and making sure that these were something that was available to the entire public and not just employers.
Did you ever receive comments from the U.S. Department of Labor that Iowa was falling outside the norms nationally for decisions favoring employers?
Yes, and that's what I think I just responded a few minutes ago on with Senator, and that's that they did comment in my review that there was a statistically significant difference and that we were finding in favor of employers more than claimants. The official from the U.S. Department of Labor, Elizabeth Schlosser, suggested that we really review that data and go over it thoroughly. I did give her my thorough explanation, but I also followed through on what she wanted me to do and continue tracking that.
Now, prior to being in charge of the ALJs, you previously had been deputy director of the entire department, correct?
That is correct.
And you're currently still housed in the workforce development
Yes.
position. Could you describe the morale of the department maybe during your tenure and if you have any ability of describing it now in your new role?
When I came to workforce development, we were just a little over a year after the CTEC scandal had hit. And I was shocked when I got in as deputy director at how low the morale was. I would say from my perspective, morale is lower now than it was then. It is, the only thing that I can say good about the morale now is that I have seen employees come together in a way that I had never seen before and kind of band together to stand with each other. That has been impressive. But in terms of people feeling down, people being concerned about what's being said about us in the press, and just general low morale, there's a very bad feeling of uneasiness that I think goes back to office closures, layoffs, and very poor communication from this administration.
Last week, we uncovered a memo that was given to fraud investigators in our workforce development, basically issuing a gag order and threats of repercussions if information was shared about what had gone on in the department. During your tenure, were you ever advised not to speak to legislators or the media or others about things going on within the department, other than things that would be confidential, would need to be confidential for your role?
What I can say about my time as the deputy director is that whenever we had any kind of a glitch, we tried to be as open and transparent with the public as possible. And I know we did have some glitches when I was deputy director and the IVR system going down and other things like that. And I think we just tried to issue press releases and be very above board with everything. And that's the only thing that I can remember ever doing as deputy director.
And then when you worked under the current director, were you ever issued any communication urging you not to speak to legislators, not to share information outside of the department?
Personally, I did not. I've heard that did happen, but personally that never happened to me. The media policy was changed in 2012 and it took me off as one of the individuals who could talk to the press. That occurred in 2012. Therefore I was under the regular policy that everybody else was in at that time. But other than that, I was never specifically instructed anything like that.
What would you say you're most proud of during your tenure at Iowa Workforce Development?
My time in the, I'm going to focus specifically on the Appeals Bureau. I think that we made a real turnaround and we're moving in the right direction in the Appeals Bureau. I already listed a number of the accomplishments that we made, and we were getting things on the right track. And I think with the way the numbers have dropped, Teresa Hillary talked about how far the numbers have dropped, and there's been a precipitous decline in the number of appeals and decisions. I'm very proud of where we got to, and I think we would have continued to move in the right direction and done it in a way that we could have kept morale very high.
I'm going to steal one of Senator Garrett's questions. Is there anything that we have not asked of you that you believe is important to our investigation today?
Not that I can think of right now.
Senator Garrett.
Thank you, Madam Chair. Thank you, Mr. Walsh. I'm going to ask you the second question that previously were asked. Have you had meetings prior to the committee meeting here with legislators or their staffs in preparation for this meeting?
I met with Senator Peterson maybe a week ago at a coffee shop for a period of time.
Is that the only staff member or legislator that you met with?
No, Bridget was at that meeting, and I think I also had a meeting with Sue Peck.
And what kind of things did you discuss at that meeting?
I was mostly trying to educate them about questions that they had about what had gone on in workforce development. And frankly, a bunch of it was doing some kind of unemployment law 101 with them and making sure they understand how the system and the processes actually work.
In regard to that, you've handed out this sheet here that shows a number of appeals for each year, for several years, and deciding in favor of employer or employee. I've got several questions on that. Number one, as an attorney, it strikes me that it would be difficult to make a numerical comparison like this just on the basis of numbers, because each case, or wouldn't you agree, each case is unique. This tells us nothing about what the appeal was, the validity of that appeal, and to just throw out numbers like this. Do you, as an attorney, believe that this really is relevant? It tells us something about a bias on the part of the judges. Is that a fair conclusion from numbers like this?
No, that's not the conclusion I reached from it at all.
All right, so you're not saying that the judges decided cases in a biased way?
No.
Okay. I misunderstood that. I thought you were saying that. Okay. Now, you do know that that's been an accusation, however, in that fair statement?
Well, I want to make sure I'm tracking with you here, so what, could you define what you're talking about for the allegation?
All right. Well, are you aware of allegations that either judges have decided cases in a biased way to favor employers? Are you aware of any allegations of that kind?
A specific allegation that a judge was pressured to decide a specific case?
Well, either, I'll ask you that, or just in general, that judges have been biased in their decision. Have you heard accusations of either of those?
Maybe make sure I break these down and make sure I understand and answer you very clearly what you're asking me for here. I am aware that judges have felt pressure that they are deciding too many cases in favor of unemployed Iowans. I'm not aware of specific instances where anybody has gone to a judge in advance and instructed a judge to rule on a case in a certain way. I think the allegations that have been made are far more nuanced than that.
So you're not aware of any allegations that, as a general rule, judges are deciding too many cases in favor of employers?
Well, as I just told you, that was actually brought to my attention by the United States Department of Labor. They had looked at the 5130 data, and they brought it to my attention. There is certainly an argument that that is the case. We do, from a year after year basis, tend to show a statistically significant difference. Now, I think what you're getting at is, and what I haven't gone into yet, is how I explain that. My personal explanation for that is, because you're right, this document by itself doesn't show you anything specifically. You have to understand the system in the context of what goes in here. What you tend to have is a lot of employers who do not participate in fact-finding process. They let it go, they ignore it, they think it takes too much time. Whatever reason, they don't participate in fact-finding, then they file an appeal and come to the hearing. the fact finders in those cases are often left with not enough information to make the correct decision. So and it tends to be employers more than claimants who do not participate in fact finding. And so my explanation for why you see a statistically significant higher level of appeals for employers is because they come in and they bring all of their evidence at that next level, and it turns out the person wasn't entitled to benefits. But because there was no participation, we didn't know what the right decision was.
All right, well, that's something that the average person wouldn't know. Thank you for pointing that out. And that would again indicate then that this doesn't show a bias. That's a good explanation. I hope everybody understands that the employers didn't present their case initially, and it would stand to reason then that more decisions would be rendered against the employer at the initial stage because they didn't defend themselves. And then you're saying at this stage they do come in and defend themselves. So I guess you and I would be a bit surprised to find that more cases on appeal are decided in favor of the employer. Would that be a fair statement?
Yes.
Okay. All right. Now, you are aware, I would imagine, that other people, and I really thank you for giving us a clear, objective statement on that issue. But I know you are aware that other people have made accusations that at the very least there was pressure on these judges to improperly favor employers.
The judges came to me and were concerned. The judges would come to me and say, I'd have a judge come to me and say, what's the deal with this poll? Why are you sending this poll out to us, asking us to define what qualifies as excessive unexcused absenteeism under Iowa law? And the director had ordered me to send that poll out to the judges and provide her with the raw data so she could see how each judge defined excessive unexcused absenteeism. And I'd sit there and I could tell, you know, sometimes the conversations were innocuous, but I could tell that the judge was concerned. Are we deciding too many cases in favor of unemployed Iowans? So they came to me. I knew they were concerned about whether the director thought they were deciding too many cases in favor of the unemployed.
How many of them came to you with those concerns?
Most of them.
How many are there?
There were, I believe there were 15 at the time. 15?
And how many of them came to you with complaints that they were being pressured unduly over that had morale issues? How many of the 15?
Again, I want to make it clear. If this isn't a matter, I'm not giving you a number where somebody comes to me and says, I want to file a complaint because I feel pressured by it. It was more of, what is this about? Are we deciding too many cases in favor? And I would say most of them, probably 10 of the judges had come to me at one point or another, whether it was about tip sheets, employer tip sheets, whether it was about the polling, whether it was about one of these silly policy things that the director was making me to try to establish a policy for uniformity. I had probably 2/3 of the judges at some point come to me and say, what is this about? Are we deciding cases too much in favor of unemployed Iowans?
Well, now you've really broadened the scope of the complaints and the conversations that you've had. I gather you say, what, 10, 17? Some of those, from what you're just saying, tell me if I'm wrong, but what I'm getting, what you just said is, some of them came in with real issues. Boy, this is really awful. Others came in, well, what's the deal on this? Not that they were necessarily upset or that their morale was bad, they were just wanting information. So, for purposes of this hearing, I'm trying to get at the numbers that were really dissatisfied, really low morale, not just somebody that came in with a question for you. Can you further break that down?
Yes, that's a good way of clarifying it. Thank you for the question. I'm talking about the people who were expressing genuine concern about judicial independence in one form or another, whether they used the words judicial independence or not. It was not just asking a question, what is this about? It was somebody who was expressing genuine concern about whether they needed to act differently, whether they were supposed to do something differently.
And you're saying 10 of the judges came to you with those serious concerns, serious issues?
Yes.
Is that right? Okay. All right. Given the fact that the director had been accused of this employer bias, should we be shocked that she might ask you for documentation on the way the decisions were made, on whether they upheld the employer or the employee? If you were being accused of a bias, wouldn't you want to know that kind of information? Is there some, does that have to show some illegitimate motive? Couldn't it just be that since she was being accused, she wanted information so she can find out if there was a bias or not?
What you're saying would make sense if she was asking you for the aggregate data. I provided the aggregate data and she had no interest in the aggregate data. What she came to me for and asked me about was the individual data judge by judge. And that's what, there was never any legitimate explanation given to me on why she would want that data.
Well, would that data show whether a particular judge was deciding cases too much for one side or the other?
Probably not. Again, it's a case-by-case basis, so it depends on what cases you get in front of you, how you decide. So no, the same reason you have to understand the context to understand the aggregate, you also have to understand the context to understand the individual judge by judge. And I had that specific conversation with her. And I even told her, and I was trying to get out of her, what do you want this for? And I explained to her that situation, the Social Security judge who had never found against a Social Security claimant. And I told her, I said, we don't have that situation here. I don't see a problem with bias with the judges. We have good judges. So why are you trying to get this information from me? And the only conclusion that I could come to is that she wanted it so that she could check out who was more friendly to the unemployed and who was more friendly to employers.
You don't see any legitimate concern on her part to find out that information so she would have some basis for trying to determine if there were judges that were deciding cases erroneously. That would not be a legitimate inquiry.
She never asked me about judges deciding cases erroneously. She wanted to know
who they decided in favor.
Correct. It didn't have anything to do with errors. And that's why I'm trying to explain to you. I told her, I said, I read the decisions of these judges. I understand, I'm close to the situation. I have a good feel for it. If we had something out of whack and I was concerned about it, I might say we need to go ahead and get this and find out if somebody does rule 90% of the time in favor of employers or 90% of the time in favor of claimants. But I knew that wasn't happening. I knew that wasn't the case, and I tried to explain that to her. She never said she doubted that. She never told me when I explained that to her that she doubted that. She just wanted the information. And she was not at all interested in this. She was not at all interested in the aggregate data.
We have heard discussions here about Iowa being delinquent in timely deciding of cases. And am I right? I've seen some figures. At one point you were 47 among, I believe the lady said it was 52 jurisdictions. We were number 47, in other words, we were almost at the bottom as far as getting our work turned around. Is that your recollection?
I did not regularly receive those reports that she's talking about when I was the chief. So I don't know where we ranked. I didn't realize that we ever got data that we were ranked. The only rankings I knew about were the efficiency standard rankings. And those are the ones that I described in my opening statement.
So you weren't aware that we were significantly delinquent in getting our cases decided?
Oh, I was aware. When I came in, we were getting less than 10% of our cases done in 30 days or less. I was very much aware of that. That was my number one goal, to get our case processing times back in. I think at the end of my first year, I can't remember whether we hit 60% or whether it was 59%, but we went from less, it was about 7%, all the way up to 60% in my first year, despite record numbers of unemployment claims and decisions.
And that, the time frame for that was what?
That was 1 year. That was in 2011.
What, from when to when?
That was in January 2011 to January 2012. And by the end of that first year, we were regularly meeting, on a month-by-month basis, we were regularly meeting the 30-day standard. And just so you understand this, I went in on multiple occasions. Part of my job was to educate the director, and I explained this 30-day standard to the director. I went in and I would take the reports in, I'd hand it to her, and I went over it several times, and I told her this was my number one goal. What she said to me when she finally got it, she looked at me and she said, "Does this affect our funding?" And I said, "No." And she shrugged her shoulder and she dropped the paper on her desk. She said, "Who cares?" Now, that's what she told me about the 30-day standard. What she wanted me to do was to get our MPUs, the minute per unit efficiency standard, and to get us into the top 10. The only thing that I ever heard from her in employment evaluations or my meetings with her was to get our MPU efficiency standard in the top 10. And we moved in that standard, we moved from 36th in the nation under my tenure to 18th in the nation. And I had us poised to get into the top 10. I don't know whether they did or not.
But you're telling us that in January of 2012, we were no longer delinquent according to the standards of the Department of Labor. Is that what you're saying?
We were on the 30-day standard. I believe for the first full year that I had, I believe we hit 60% or possibly 59%. The goal is to get 60% of your cases in 30 days or less. And I believe we either hit that number or we came in just under.
And you had you instructed the judges that that was the standard that the feds required and worked with them to make sure that they got up to that standard?
Yes, and the judges all knew it too. The judges knew what it was, but yes, I explained to them that that was my goal. It wasn't the director's goal, but I still strived towards getting that because of the reasons that Devon talked about earlier, that those benefit checks, it is so important to get a resolution to this stuff timely. But you do have to understand, this was one of the largest recessions in U.S. history, and the numbers were just through the roof. For much of the time that we were not making the 30-day standard, even if the judge had decided the case on the same day that they got the case assigned to them, they would not have made the 30-day standard. And that's what was happening in 2010 and 2011. So when I came in, we had a major mess that needed to be turned around. And we did it right away.
Mr. Walls, that's a very curious argument in my opinion. Didn't the recession affect all these other states too?
Yes.
It did.
Certainly.
Yes, and yet we were 47th among the 52 jurisdictions. How can you blame the recession on us being 47 out of 52 when all the other states had the recession? In fact, a lot of them had worse problems than we did. So how can that be an excuse?
Point of order. I think in all fairness, Mr. Walsh has testified to what he experienced when he came in, 10%. He took it from 10% to 59% or higher in that 1 year period. Now you're asking him to testify about what the rest of the country was doing and where we ranked when he was unaware of our rankings as director, as he testified in his statement. So I'm trying to understand where you're going here with these questions. You're asking him to pull data that he's already admitted to the committee he doesn't possess. So I'm trying to see the relevance here, and I don't see the relevance.
Well, let me tell you the relevance. He just stated that the reason we were so far behind was because of the recession.
When he came in,
yes,
that's what he said.
And all I'm saying is, all the rest of the country suffered from the recession also.
Senator Garrett?
Yes.
I agree with Senator McCoy here. He was using state-specific data. You're trying to use national data. Let's stick with the data that he is aware of instead of asking.
Okay, I guess we made the point.
Can I just say, if Director Whalen had come to me and said, Joe, we're 47th in the country, you need to fix this, I would have fixed it. I would have busted my butt to fix being 47th in the country. No one had ever made any issue that we were 47th in the country. I'd never seen that information. My goal was to get us up to that 60% number. And I did that in spite of the fact that she didn't even seem to care about it. What she cared about was this MPU efficiency. That's what I focused more of my time on, because the person who signed my paycheck and signed my evaluations that's what she was telling me to focus on. So that's what I did.
Was part of your duty providing guidelines and instructions to the judges on how they were to, what their job entailed, how they were to perform? That was part of your job.
Yes, I was a supervisor for all of the judges.
And it was part of your job to do a performance review of each of the judges?
Yes.
And did you do that each year?
I feel I did a very good job of giving direct feedback to all of the staff on a regular basis. I did not put them on the form that's required by the state of Iowa and do the official paperwork that is supposed to be done.
All right. So the state says you're supposed to do that, but in your judgment, it wasn't necessary, or you didn't have time to do it, or what?
I did have to set, I'm sorry, go ahead.
Well, you substituted your judgment for the requirement that the state imposes on you. Is that correct?
No, let me just say this. I should have done the evaluations, and I wouldn't have to sit here and answer questions about it. I didn't feel the state evaluation was an effective means of giving feedback, and that was my opinion. The director knew that I had not done evaluations in 2 years. She knew it. She got a report that showed I was in that side of the building, and I knew that she got a report that says who has done their evaluations and who doesn't. Had she ever come to me and said, you need to get these evaluations done, I would have. In fact, when she did, in May of 2013, I immediately started preparing the evaluations and told her I'll get them out immediately, and she told me to hold on.
When you're talking about getting the judges up to stand when they were not performing the way they should, and you work to get them up to where they need to be, do you have any written communications showing what you did in order to tell them what they needed to do and to get this job done? Do you have anything at all emails or anything in writing at all to show what you did at that time?
All of my files that I kept for personnel purpose were in my office when I was walked out the door. I don't still have any of that documentation.
Were there any written documents that would show what your efforts were?
Yes.
All right, and so they would be what? Communications with the judges, with Teresa, whatever? What?
Both.
Both.
I preferred to handle it in person or verbally with the judges. If there were performance issues, I prefer to talk to them. I feel email as a written communication can come across as hostile and confrontational at times, and I prefer not to do that, especially if I was dealing with some sensitive issues. Plus, I didn't feel like it was a very good tool for getting to the bottom of what was really going on. So most of the time, I would do that verbally. Sometimes it would be followed up with documentation of what had occurred, what had occurred if it had gotten to that point.
So you had a verbal conversation then with each judge explaining that they needed to get up to the standard that the Department of Labor had. Is that what you're saying? It was verbal?
I had verbal conversations with the judges, in particular if there were performance issues, particularly in timeliness.
Well, so what does that mean? You had conversations with some of them, but not all of them?
Some judges I was having no personnel issues with in terms of timeliness. And look, anytime an issue came to my attention, I would address it.
Well, you've told us that I came in here and things were a mess, and I fixed it in a year. I'm trying to figure out what you did.
Oh, okay.
And,
well, that's different.
In what form? If there were written communications demonstrating what you did, or it was all verbal, or...
Your second question is a completely different question than when you started out asking me, because the main ways that we got so that we were regularly making the 30-day standard didn't have to do with pushing employees more, but it had to do with process changes to make the agency more efficient so that we could assign the cases differently. The other big thing that I did is I struck an agreement to borrow a couple of the work comp deputies to come over and help out with our caseload, because again, when I started, judges would get files and all the 30 days had already passed on all the files, so there was no chance that any of them would make it. The volume was just too high. There wasn't even a chance they could make it because we had never staffed up at all during when the Great Recession happened. And so what I would say is the main reason that we got things under control and either made that 60 to 30-day standard or came very close to it, the main thing that I actually did was struck an agreement to borrow 2 work comp deputies for 6 months to help with the caseload and get the backlog caught up. There were other process changes that I instituted in terms of how we assigned cases and when we assigned cases to make sure that we could get cases assigned quickly that could still make the 30-day standard.
Do you know if the judges now are handling more cases and deciding more cases than they were back in the bad old days when we were far behind?
I don't have first-hand knowledge of it. I just have what I've heard from judges that they, what I always tried to set the standard at was 28 hours. That's not necessarily 28 cases, but if you consider a two-party case, one two-party case is an hour unit. If you have a one-party case, that's a half-hour unit. And so I tried to have 28 unit hours of cases for the judges, and that's what my goal was for them.
So, was that more than they had been doing, or the same? I don't think that answered my question.
When I took over, what had actually happened is there was no set standard. I ultimately did set a standard. Judges had kind of developed schedules and routines over time. The scheduling clerk had kind of done her own thing without much direction from management. And so when I got involved in set the 28 standard, there were really, the judges were kind of all over the map in terms of the number of cases that they did on a weekly basis.
Was the 28 standard you talked about, was that in writing? Or is that just something you're talking verbally about?
I honestly don't remember. I know it probably was discussed at a staff meeting, and there'd probably be minutes from a staff meeting. I don't know that I ever put out a guidance on that. Sometimes after a staff meeting, most of the time after a staff meeting, I would do some kind of recap of the minutes, at least the minutes that I felt were important to me as the manager of the unit. But I honestly don't know.
Okay, all right, well, trying to figure out how formal a policy that was. You've got a suit against the state right now, is that right?
That is correct.
And it involves a lot of the issues you've talked about here in your state.
That is correct. Yeah.
Has it been a jury selected in that case yet?
No.
Is there any issue with news reports of your testimony here being read by potential jurors? Is that an issue that anybody should be concerned about?
Not that I'm aware of.
Okay. All right. How much are you asking for damages to the city? Where?
I don't believe that there was any number pled in the petition. I just want to be made whole for my losses.
What would it take to make you whole?
I don't know. I haven't sat down with my attorney to discuss that. The case is not going to go to trial until next year. I don't even believe discovery is getting set out on it yet, so it's going through the long, slow process in our justice system.
All right. Thank you. Thank you, Madam Chair.
Thank you, Madam Chair. Thank you, Mr. Walsh, for your testimony today. I just have a few follow-up questions. One issue I wanted to ask you more about were these tip sheets.
Yes.
I've looked online at the tip sheets that are available through Iowa Workforce Development's website today. To me, they seem pretty much like what you find in AMJUR, American Jurisprudence, or ALR, a restatement of what the current law is that anyone who's interested can use to identify what is deemed proper behavior. Are those tip sheets the same ones that you stated earlier were geared toward helping employers avoid having to pay unemployment benefits?
I haven't looked at what's online anymore. What I was testifying about is what the director told me to do. And what she told me to do was to develop an employer tip sheet that she wanted to be able to take out to employer groups as kind of a how-to guide for avoiding paying unemployment benefits. I'm the one who directed her that was not okay and that was not something the Appeals Bureau could be involved in. So that's how that went down. I think it became far more innocuous by the time that it actually got done. What I testified today about was what she asked me to do.
And how long have these tip sheets or something similar to them been on the Iowa Workforce Development website? Or been available to the public during this last?
These tip sheets, were new. They were branded new. They were kind of a new idea. We had always had frequently asked questions on the website. Those were mostly about process issues. What's going to happen at my hearing? How do I file an appeal? Those types of things. These were new in that they were geared to be legal advice. And that was what was different about those.
Well, okay. In looking at the tip sheets around there now, I certainly don't think many attorneys would deem them to be legal advice.
And that's fair, and I haven't seen them. Again, I'm telling you what she told me to do compared to what actually ended up happening. For example, though, one of them with the intoxication. This was something that she was always bringing my attention, that people could be intoxicated at work and end up drawing benefits. which is not really true. The employer just has to prove that they're intoxicated. And we had a meeting after meeting about this, and I tried to explain this to her. And she told me, she said, I want a guide of what evidence you need to have as an employer, so that, and it needs to be a list, and so that you can know exactly, if you're an employer, what you have to do to be able to fire somebody and not pay benefits. And I said to her, I said, we can't do that. A judge cannot give that legal advice to anybody. We can't write it up so that an unemployed Iowa knows how to beat the system if they happen to have a drink at lunch and come back and get fired. We can't write it up that way for employers. And so everything I did was to try to get the appeals bureau to be less involved in it and make sure the judges were not giving legal advice to employers. What ended up out there and what's on the website, I don't know. I'm telling you what she asked me.
Were any tip sheets put on the website while you were still employed at IWD?
I think so, but I wasn't involved in that. I got as I mentioned, I brought the appeals. I got it so that the unemployment division was brought into it, and that Carrie Coombs and the public relations team was brought into it. So I didn't have anything to do with the. I think what we did is I would have a judge look at it and sign off and make sure there were no egregious errors of law at the end of the day.
Was there anything in writing where she expressed her desire for you to put together the tip sheets in the fashion that you just communicated, or were these all oral communications?
The director did not like to communicate in email. She didn't want a record of the conversations. That's what she told me.
So all your conversations with Director Whaler then were verbal?
Yes, as you can see from my documentation, I would sometimes go back and document my conversation with her because she didn't like to put. But it's not true that she did put things in writing to me. It was rare and she didn't like to do it. That's what she told me.
You mentioned too that she used fear to exert her will. Are there if you have anything in writing where she threatened you in any way to take a certain course of action?
I would have to review my documentation.
Did you ever feel physically threatened?
Physically threatened by Director Whaler? No. No, she made people fear for their jobs. That was her primary tool, is to make people think that if they, every leader's got a toolbox that you go to, right? You need to inspire somebody, you come up with a motivational speech, you come up with a reward to give them, whatever it is. Every time she needed to get something done, she reached down in that toolbox and pulled the same thing out and just tried to scare somebody.
How would she scare someone? Is there anything in writing where you can point to that she made some kind of threat or anything like that to try and scare somebody into doing something?
She wrote hostile emails at times. I know I have hostile emails from her. I'm not sure what you're. No, she wasn't, and she wasn't stupid. She didn't write if she didn't put something in the email that was specifically incriminating, and it was all more subtle and nuanced than you're suggesting here. But that's the way she did things.
And just to follow up with Senator Young's earlier line of questioning, when you had your meeting with Senator Peterson and members of the Democratic caucus staff, did they give you any kind of indications as to what kind of questions they'd ask you here today?
No.
Did they ask if you prepared to testify about any particular matters?
No, I gauged from the kinds, they were trying to find out what was going on, and so I gauged from the kinds of questions that they were asking me about what had happened, what kind of things I should be thinking about.
Did they give you any direction on how to present your testimony or how to answer questions, coach you?
They told me to be honest.
Okay. And did they suggest any certain facts or items that they wanted you to bring up during your testimony today?
Not that I can recall.
And have you sent any documents or emails to any legislator or staffer relating to the subject of any of these proceedings?
I believe I may have given a packet, I'm not sure, the same packet that I would have given today of emails and information, I may have given to Senator Peterson or Bridget, I'm not sure.
Well, there'd be a record of that somewhere. Okay. That's all the questions I have.
Senator McCoy.
Thanks for being here, Joe. This has been an interesting day and interesting testimony. I just want to, for the record, state that you and I have not met in any dark parking garages. Is that accurate? That's true. This meeting or any other time. Just a little humor for the sake of the committee.
I chuckle.
I wanted to talk about two things. One is I want to talk about your case. And I want to talk about your future, and I want to talk about where you are now. You filed this case, and I've read it, and I see where you're going with that. And you were hired as Deputy Director of Work Comp Division, and Mr. Godfrey's moved on to other greener pastures. So what happens to you now in that role? What is your current position?
I'm the Deputy Workers' Compensation Commissioner, and currently there is no commissioner, there is no acting commissioner, there is no interim commissioner, there's no commissioner at all. Iowa Code 86.3 states that deputy commissioners can do final agency action. We keep hearing rumors that we're going to hear on a new commissioner very soon, so we're trying to delay having to figure out what to do here, but we're in kind of a situation right now where we don't have any leadership within the agency and we're not exactly sure what we should be doing.
Is your position merit or at will?
It is a merit position.
Okay. And it will remain merit position to the best of your knowledge?
As far as I know.
Okay. Okay. I you know, the ball's moving fast out of Brenda Finley's office. There's been a lot of changes across the board and lots of folks that have been reclassified, over 300 employees. So that's why I asked that question. There were questions about the tip sheets, and I agree with Senator Schneider. I've looked at them, and I see no problem with what's posted online. The memo that I'm referencing right now was actually an email that came from the director to Devon Lewis, Judge Lewis, and it states very simply, please write this from the perspective if an employer who would not necessarily know or understand Iowa law needed to understand Iowa law as it relates to absenteeism or what constitutes absenteeism issues. Did you get copies on any of these when they were going through edits or any of these types of emails?
Yes, I don't remember that one that you're talking about specifically, but yes, and what would happen would be I would usually either assist in writing the tip sheet myself, or try to pass it off into somebody over in Mike Wilkinson's unit and have them write it, and we just review it. And then, you know, we would have some kind of a final appeal sign off on it at that point. Okay, and again, your effort to reclassify these or rename them employer, what was your, I mean, what was? Public, I call them public guidance memos.
Guidance memos. That certainly, I think, might be in order for the department to look at how these are classified, because as I read them, they were, they were pretty innocuous legal, you know, they wouldn't be legal advice, but they were more of, you know, hey, this is something to look at, or this is something to consider. And so I definitely understand that. In terms of the existing lawsuit that I know Mr. Godfrey has against the state is defending that lawsuit to the tune of $550,000, I believe, right now. Do you know what the state's position is on your lawsuit? Because I haven't heard of the number. Have they retained private counsel at this point, or are you aware of that?
My understanding is they have not retained private counsel. The Attorney General's office has answered my petition, and I know no cost analysis has been done on it today.
Okay, thank you.
I have just one real quick question, if you could walk the committee quickly through. I think we've gotten to the points of fact finder, ALJ, and there's an appeal process. And then if that doesn't work, then they can take it to district court. Those would be the stages where an employer in Iowa could go to, correct?
Yes.
And before it gets to the fact, or explain the intake quickly and scheduling, so they have an idea of how these cases get assigned.
Scheduling and appeals?
Yes.
Okay. So a party gets a fact-finding decision. It's either an employer or an unemployed Iowan, and they don't like it. So they file the appeal, and that's where it goes to the Appeals Bureau. The Appeals Bureau goes to an intake clerk who stamps it in, what day it came in. It's very important so we know whether the appeal was timely or not. And from there, a file is opened both on the computer and physically, and then it's sent to the scheduling clerk. And when it gets to the scheduling clerk's desk, then she gets a whole series of these appeals. And at that point, she goes down through the list and makes the assignments essentially randomly at that point in time to each of the judges until they have the requisite number of cases. And you try to do this in a way that makes the most sense so that you can get the most timely decisions out properly. But it's all, at that point, it's all random. Judges are not assigned cases in any particular way that I'm aware of. At least that's how I identify it.
Thank you so much for your testimony today.
Thank you.
Our next group are administrative law judges Marlon Norman, Susan Ackerman, and Monty Hendricksmeyer. I think we can use both sides of the table so we're not too crowded.
Yeah, I think so.
Did you get the right name?
Yes. Oh, there's a button for when you're both on the kind of, okay.
Deb will give you the
Okay, please raise your right hand. Okay. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I do.
I affirm.
Thank you.
Thank you for being here today. We'll start left and work our way to the right. Do any of you have an opening statement that you'd like to share with the committee today?
None for me.
I do, but can you start?
My name is Bonnie Hendricksmeyer. I was an administrative law judge for workforce development from January 4th, 1991 until May 30th, 2014. I intended to work until age 62, but I was prompted to resign by the hostile work environment and the undue pressure brought by the administration. And I left. Thank
I'm Susan Ackerman. I've been at workforce as an ALJ since 2000. Before that, I was at Department of Corrections at Mitchellville as an ALJ. I went to workforce because the judges were working at home. So I had written, once I learned about getting the subpoena for the hearing today, I've written probably 5 or 6 different opening statements, but I threw them all out this morning and wrote a new one after watching the news and seeing the governor and the lieutenant governor standing behind Director Whalert. The imagery, what it conveyed to me and what I think it was intended to convey is that they're standing behind her no matter what, and I find that to be a problem because I don't feel the administration has investigated what's going on with workforce. I'm not denying that they may have interviewed some upper level management, but no one's talked to us. And we're the ones involved, so without doing that, they don't have the facts. So, we're all public servants, the administration, the judges, all of us. And what that means is we represent and serve the people of Iowa. The people should come before the party. The only thing that I can compare what the administration is doing by standing behind the director is the unconditional love I have for my children. But even that is the same as what's being done here in politics today on all levels and with both parties. I love my kids with all my heart and will always support them no matter what, but that doesn't mean they're always right. It doesn't mean that mistakes haven't been made. And it doesn't mean I'm supposed to agree with their actions, with what they do, especially when I don't know what it is. In addition to being a public servant, I'm a judge who has to look at the facts of each case and make a determination based on those facts. Doesn't mean I get it right all the time, or that I won't get it wrong, because I have. But it does mean that I have done my best to determine what's going on. And that's all we want here. We need the members of both parties to listen to the facts and to make a determination after that, not before that, and not based on which party you belong to. And if you really want to know why I have personal objections to what's going on, other than the obvious ethical considerations, is that I'm a registered member of the governor's party. And I'm not the only one in our group. So when there have been allegations that have been partisan politics or Washington-style politics, that's upset me because nobody's talked to us. I'm not in politics. This is not a political issue for us. In fact, our job requires us to be non-political. I'm going to end my comments with a quote from Elie Wiesel, who's a Holocaust survivor and activist, writer about human rights, and winner of the Nobel Peace Prize. He said, "There may be times when we are powerless to prevent injustice, but there must never be a time when we fail to protest." We, the ALJs, have been powerless to stop what has happened in our Department of Iowa workforce, but we won't stop protesting. Whether you're right or wrong does not depend on whether you're a Republican or a Democrat, and it does not depend on whether you're an employer or employee. It depends solely on the facts.
Thank you. Senator McCoy.
Thank you. If I could, just so that in all fairness, Judge Norman, if we can just kind of get a little background of how long you've been with the department and where you're.
I'll give you a little background.
Sure.
I grew up in Nebraska, a poor farm in northeast Nebraska. About 5 miles farther north than the best farm in South Dakota. And unfortunately, I went to law school in Nebraska, and I have experience in insurance defense. I worked for a law firm. I did criminal defense. I've tried and won murder cases. I went to work for a Fortune 500 company, managed a litigation department with a $17 million budget. I've done administrative law for, I think, 27 of my 30 plus years experience. came to the state in 1990, then a deputy workers' compensation commissioner and administrative law judge, retired during that time. And today I'm an administrative law judge, not unemployed.
I was gonna say, you don't look old enough to have done all those things, holy smokes.
That's my grade.
So let me just ask this, and I'm just gonna let you work your way down. What's your definition of judicial independence, and why is it important in the roles that you play at workforce development?
As a lawyer, we have an ethical obligation to maintain judicial independence. We're governed by the Iowa Code of Administrative Judicial Conduct. And judicial independence means we have to maintain the appearance of impropriety in all adjudicative functions in contested cases. I think that's further defined by the Department of Labor. We're actually under Social Security law and federal law. And there was a case in Maine, and I think they quoted it quite well. That was a case in Maine where the government was trying to game the system in unemployment. And I'm going to quote from that case. Under federal law, the UC appeal hearings must be fair and impartial both in fact and appearance. Political interference or undue political influence, even in appearance, can potentially destabilize the appeal process by, for example, affecting hearing officers' deliberations or morale, undermine the credibility of the state's UC program and generate additional workload, more appeals. And I think that's the best definition I can come up with.
Sure.
The same question?
Yeah, judicial independence, your view?
Judicial independence is the freedom to make our decision without influence or control by anything other than the law and the facts of the case.
I don't know what I can add to that except to say, as a professional, it is my obligation to make my decisions based solely on facts as they relate to the law being the Iowa Code, Administrative Code, and Supreme Court and Appeal Court cases, without anyone having a departmental policy that we are to follow.
So do you think Director Waller's practices affected your judicial independence in that manner?
Certainly.
And how?
Well, I told her personally at my performance evaluation on September 24th, she asked me, do the judges have a problem with me being a non-attorney? And I said, yes, we have a great problem with that. You're a political appointee from an administration that has never been known for a favorable attitude towards labor. I said, we are professionals. We have a code of conduct, and that code of conduct says that we are to avoid the appearance of impropriety, and this looks improper. I quoted to her what my ethics professor said in law school. It doesn't matter that you're not doing anything wrong. What matters is how is it going to look when it gets to the front page of your local newspaper. And that is precisely what has happened. It hit the front page of the newspaper, and here we are. Is this the appearance of impropriety? I think we have substantial evidence to that effect. And I think that very seriously makes us look prejudiced. We've got someone who appointed herself unilaterally as our supervisor after removing the cushion that we had in the chief administrative law judge, who was also a lawyer. Any lawyer knows that the appearance of impropriety is very serious, and more people probably get suspended, even for a couple of months, for the appearance of impropriety. They mixed up a little bit of the funds. Nobody lost any money, they didn't steal any money, but it was the appearance of impropriety. That's what matters on judicial independence. Other than that, we're just judges like they used to do in Chicago, back in the bad old days of Prohibition and alcohol. We look like we're being bought or we look improper.
I bet that was an interesting meeting with Director Waller.
Well, I also told her why I was retiring, and that was an interesting meeting. You're correct.
Was her response? What was her response?
Oh. That was her response. No.
Okay. Judge Ackerman?
I wish you'd ask her why she retired first.
I'll get to that.
And you're asking if I have felt that I've been pressured?
No, I asked how
I asked how the director's influence has impacted judicial independence.
Well, it's impacted by the work environment that she has created. We're doing 30 hearings now, which prior to July 13, we never did a 30 hearings. And as the lead workers told you, that does not mean 30 cases, it does not mean 30 decisions. In addition to the high number of cases that we're doing, the focus is on expediency, getting the decisions done. We have reports coming out the following Monday, which I refer to as the shame reports, because if you have a case on there that is not submitted, if it's past the 30-day deadline, and like they said, we could hear the case when it's beyond the 30-day deadline. If we don't get it done that week, it goes on the report, and the report is sent to the managers, all the other ALJs, and it's listed how many judges, the name of the judges, and how many cases they've got on the list. I personally complained to lead worker Teresa Hillary and said, I understand that you need to, that you might want to put the list of cases as far as how many didn't get completed on the report, but I don't see the purpose of publicly shaming the judges if they had a bad week, if they didn't get their cases in. And those reports have led to judges being brought in the office because they're behind. And they're brought in the office for purportedly more training. If I could go on, we do an average of 1,000 cases a year. And our former chief judge, Dan Anderson, was a great numbers guy. As of September 30th, 2010, I had done 10,459 cases. So if we have cases that are overdue, we're getting pulled into the office for training. And Bonnie, in her tenure, she probably did well over 20,000 cases. I've probably done close to 15,000. I got pulled in the office. It wasn't for being late, but I know another judge who's been there longer than I have, who's probably one of the best legal scholars we have, and she's been pulled in the office because she had late decisions on the shame report for 2 weeks in a row. So the pressure is so intense that it makes it difficult to write. I mean, everybody's written something for school, for whatever. And you have to be, your mind has to be calm enough to be able to know what you want to say, how you want to say it. And when we're writing 30 to 38 decisions a week, and we're so upset because we're going to get in trouble and we don't know what's coming next, it makes it difficult. I don't know if that answers it, but
I think it does.
Being supervised direct, we're employers, we're also adjudicators. We're supervised direct by a person who does not have a law degree, is not qualified to act as an administrative law judge, cannot hear and write decisions, and up until just a few months ago had never sat in on hearing. There's some real ethical issues there for lawyers to have to deal with that kind of issue. That is why it's best to have a chief administrative law judge who is at will to act as a buffer, so they understand those ethical considerations and don't put you in those dilemmas. As Susan said, one of the dilemmas is setting the schedule. You heard today that we're in line with the number of cases that we do based on other states. Every state has a different procedure, different standard. What we have to do in a hearing is different. What we have to write in a decision is different. So that's compared apples to oranges. I say that we're probably on the high end, because I saw the statistics myself. The director passed those around. We're on the high end of that number. But it goes on experience. I went through the floods of '93 when we had massive numbers of cases, and we adjudicated them all and received accolades of how well we did. But in reality, the true metric that counts is who wins and who loses. And as you push those numbers up, there is a breaking point. There's always a breaking point. It's the same thing if you do jury trials. You go to a jury, you don't want to send your case to when they're tired and hungry. You want to give them a fresh start so you get a good answer, the right answer. That's what's happened with us. So it's just a slow, total breakdown over a period of time. Our schedule was set by a person who doesn't try cases, can't try cases, and doesn't really have that experience. This workload is excessive. It has changed who wins and who loses in cases. And I stated this in meetings many times. This workload will change who wins and who loses. And if you look at the statistics, I was told in the meeting that it's been a slow 5% move away from giving employers wins. And if you look at our statistics and how our hearing caseload went up, that's it. So I think many of you will be surprised that the higher caseload goes against the employer because the employer has the burden of proof, and ALJs just get too tired and they don't ask that last question. You just get burned out. So as a result, we have a lower morale. What's low morale cause? It causes people like Bonnie Hendricks-Meyer to leave, Randy Stevenson to leave, Vicki C to leave, high experience, high performers, some of the top people you could ever want in an adjudicatory unit. Soon you end up with a unit where untrained people are training untrained people. That's what I fear, and that's where we're moving. And I've told the director myself, after my next vacation, I will not come back unless there's a paradigm shift in the management. It isn't working. And one of the things that I can show that there was a comment made about maybe moving people into the office and away from home changes the metrics and get things done more timely. It hasn't worked for me. It hasn't done any difference to mine, nor for Bonnie, nor for Randy, nor for Vicki. It doesn't make a bit of difference. It's the person and how they exercise judicial independence. It doesn't make any difference whether they're working at home or not, because here's our schedule. Here is a schedule. This is 1 week schedule. Every line on that piece of paper is a hearing. Now, here's what's going to surprise you. We have 3 lead workers. There's their schedule. And sometimes, their schedule. That is what's caused most of our problems, and we haven't had the people to do the work. Now, what I want you to think about is when Joe Walsh was there, we had 14 ALJs performing a full-time schedule. They all had this. Joe Walsh was our manager, and he had a partial schedule. He had this. Now, we have 9 ALJs performing a full-time schedule. Went from 14 to 9. We have 4 people with part-time schedules, 3 lead workers, and 1 person kind of facing into retirement. That's the problem. That is what's, if we had everybody on board, everybody doing all those cases, I don't think we'd be here right now. Because it wouldn't have been so darn stressful for us, and all these other things that happened, we probably could have coped with it. That's where we're at. And I think it's the lead worker program, which the director loves. I think it's been a failure. I corresponded with her, I talked to her, I knocked on her door, and then we discussed it, but she stands by it, and I stand by my statement that it has been a failure. And that is one of the reasons why we're here today.
So the line workers, the
lead workers?
Lead workers, excuse me, the lead workers, they said it's about accountability, holding judges accountable. And you guys just don't like accountability. And that's what you're complaining about.
Pure unadulterated baloney. As Marlon said, it's not a matter of geography, it's a matter of your character. If I had a decision that was submitted after 30 days, it was because the hearing wasn't held until after the 30 days. There was a time period during that veritable tsunami of appeals during the economic meltdown of 2008 and 9 and 10. We couldn't even get the hearing scheduled until nearly 45 days. And I got my decisions in by the end of each workday. Occasionally the next morning when I needed to calm down after a particularly raucous hearing, and I wanted to make sure I wasn't making my decision on any other basis than fact and law. So moving me into the office did not make any difference whatsoever to my production value. So why I had to go into the office has never been explained to me. There's some rhetoric about being part of the team. Well, I don't think judges are a team. I do my hearings, Marlon does his hearings, the other people did their hearings. We're not a team. We're independent judges. If I can get my work done at home, there's no reason for me to be in the office. They want us, they can go and walk by our office and say, well, where were you between 2 and 2:20 today? You know, or why did you go home early? My work was done. They seem to think if we're in the office, we will take phone calls from people inquiring about their decisions. I worked for that department for 23 years, and I never yet had anybody knock on my door and say, I have a question for you. They emailed me, they called me, they sent me an instant message. Because they know we're in hearings most of the time. Nobody knocks on my door. They say, can you take a call? You know, they email me. They instant message me and say, can you take a call? And I can do that at home just as well as I can do in 1000 East Grand. That's bogus to say that our production increased or was more efficient if it came into the office. That's just not true. Not for me, not for Randy Stevenson, not for many others.
Any comments on accountability? You guys just don't like accountability?
I'd like to comment, when all of us have worked successfully from home for 10, 11 years, and everything we do is documented. Now, before we recorded our hearings, we posted them. Now we've got this system that you can actually look on somebody's schedule and see that they're in the middle of the hearing. They've got lists of when we turn our decisions in, the time and the recordings that shows how long the hearing is. Everything's documented. The advantage to working at home is that these hearings are stressful. People who aren't involved with them, have never had any experience with them, they don't understand. We're dealing with sometimes a crisis every hour. When you do 7, 8, 9, 10, which I've done hearings in one day, you know, it's very difficult. The advantage to being at home is that you can take a break, you know, once you've done your 8 to 10 hearings, go get something to eat, you know, watch the news, whatever, and then come back and work. When we're at home, probably 2/3 of us work well into the night. We work on the weekends. There's some that are able to get their decisions done. There are others that need more time to figure it out. So accountability, it's always been there. There's no question as to whether or not we're working, because they can check everything. We have a system that shows when it's an instant communication system. And it shows when we're at our desk, because we're supposed to have a green light. And for 10, 12 years, our boss, Dan Anderson, always told us, you know, if our work was done, we could leave. And we get one writing day a month. Some of us would stay up the whole night through the night Thursday night, so then we could have Friday. And we saw that as a benefit to us. But now, we're expected to be there 8 to 4:30. And moving into the office is counterproductive because, number one, they don't have the room. The lead workers, well, I don't know about Steve, but Devon's got probably the nicest office in the building facing the Capitol. She's got a key. Teresa might have a key, I don't know, and Marlon's lucky he's got a key. But the rest of us, we share offices. They're not set up ergonomically for us. We're just kind of put in there. So we have to tear down, and some go in for a week at a time. And I was told, and the director in a meeting told me that we could do whatever schedule we wanted to. If we wanted to come in every other day, we could do that. I take my computer home. Well, then it changed. We have to come in every 2 weeks. But it's not a matter of accountability, because we're accountable. It's just counterproductive. And Devon talked about working in the office, and when they first started talking about it, she sent out, we all were talking, and to each other outside the computer system, and she sent an email saying that since we went home, that she had somebody do a number crunch, that our caseload increased 45% since we moved home, and that was in 2000. And Joe tried to get the director to tell him why she wanted us in the office, and she said she gave him a blank stare. And Joe told the director that our productivity would suffer and that we are caught up now, and moving us might jeopardize that. And Devon wrote, but her response was something like that she finds that significant changes in times of high pressure make people more efficient and effective. And at the very end of this letter, Devon wrote, he knows that we are burnt out with no light at the end of the tunnel and no end of the tunnel to even light. Those were her words before she became the lead worker. And this was in 2011. It's a high, stressful job. And as I said, we're not together, we're kind of spread out through the building. And just like this place here, the air conditioner isn't really good. And I was working in the office there, and I had issues with heat. And it was after 3, and I needed to get my decisions done. So I drove home, got right back on my computer, started working, sent a decision in, so that's verified, and I sent it in right at 4:30. At 5 o'clock, I got an email from the director asking me why I didn't finish the workday at the office, because it's my 2 weeks to work in the office, which she was out of town, so it was one of the lead workers who had checked on that, and she said, is there a reason? And I said, yes, there's a reason. And I explained, you know, I was working. I couldn't work there anymore. I needed to get work done. And I said, I didn't think that the desk that I was sitting at would matter more to you whether I was doing my decisions. It's become, in fact, I wish that she would pull us into the office the whole time. They don't have the room to do that, but if they did that, that would be better for all of us, because then she couldn't hold that over our heads. And not to mention, one of our judges has to work in the office full time, and I believe it's a direct result of one of the lead workers' dislike for her. Because those documents that the Oversight Committee requested, probably 20,000 documents, I went through every page of them. And if you also went through those documents, you can see the lead workers' conversations back and forth to each other. Their disparaging comments about the rest of us. We say something to one of them. There's one there that I said to Devon that I said, I had this claimant, you're going to have him. I was going to try to do it, but I couldn't do it, so have fun. And she didn't respond to me, of course, but she sent Hillary an email, WTF. And the tone that you hear in the emails that are on your website is how they treat us. And if I might also say, the director's fully aware of this. And she condones it. Because every single one of us, judges and clerical, have complained about bullying. And she listens to us, and nothing is done. And at some point, I want to read you something from one of the lead workers to a different judge. So
Okay.
Can you hear what you say about that?
Yeah, let's try to keep moving here. Do you want to add anything on that issue?
Afraid I'll get started like Susan, I think we'll stop. Yeah, I'm really concerned about judicial impact, so I don't want to talk about that one.
Yeah. The issue of judicial independence is important. It's my understanding the Department of Labor is conducting some interviews, and my question to you is, are you aware of DOL's inquiry? Have you been contacted? Are you comfortable talking at all about where they're going, DOL?
They called me and I talked for about an hour and told them essentially what the situation was and what I thought. And then had a subsequent conversation with Betty Castile. I said, Betty, I really want to be part of the solution, not part of the problem. I want to work with Director Whalen any way possible, and I'm going to try to find a way to continue to have a constructive conversation. And then we discussed that issue for about another hour after that. And as a result, I continue to email and knock on Director Whalen's door to see if we can find solutions to bring peace to the department. That's about it.
Anyone else?
I spoke with the DOL briefly, told them basically the same that I told you about how I had advised Director Whaler about the appearance of impropriety. But I did want to add one thing about working in the office. I do want to point out that I think that people working at home take less sick leave. I sprained my ankle very badly a number of years ago, and without even me asking, the doctor said, I don't want you working for the next 10 days. Do you need a note for your employer? And I said, I work at home. If I can go to the bathroom, I can go to my office. So that was 10 work days where other people weren't having to do my work, 10 days where they weren't having to reschedule my hearing. So working at home is actually more efficient in terms of, and people with small children were constantly taking days off because school days, snow days, they couldn't come in because they didn't have the child care. We didn't have that problem when we worked at home. So I wanted to add that as far as the efficiency of working at home.
And that's all very helpful. With respect to the director's influence, were you in any way directed or feel that the outcomes of your decisions were being monitored, suggested that your decisions were inappropriate based upon review by the director? I mean, she is your supervisor, so she's a non-lawyer supervisor. So what I'm trying to get a flavor of is what kind of feedback she gave you on the outcomes of your decisions.
Well, as they say, I'm glad you asked that question. The woman in the fountain case, we got a lot of brouhaha. Woman worked for a bank here in Des Moines, but she was on vacation in Kansas City at a baseball game, got drunk, splashed around the fountain. She was known as the fountain woman, fountain lady. Got arrested for public intox and trespassing. Got fired when she got back. And of course, this was all over YouTube and the local news. And I had the hearing. I'd never heard of this before. I had never seen any. I don't do YouTube, and I hadn't seen it on newscast. And I found this was not job-related misconduct. She was on vacation, on her own time, in another state, and I allowed her benefits. They didn't establish any substantial job-related misconduct. Well, then Clark Kaufman did an article in the paper, as he does occasionally, reviewing workforce cases. And the hearing was on October 29th, 2013. So on October 5th, after the newspaper story was published, Director Whaler wrote to me, please explain the substantial level of misconduct that would uphold the denial of unemployment benefits. Considering a published policy that prohibits off-duty conduct that either reflects poorly on the bank or causes management to lose faith in an employee. Let's suppose an employee was charged with trespassing and resisting arrest in quite a public venue, plus a charge of soliciting a police officer, plus admitting to being under the influence, all publicly documented. Because I am trying to understand the legal requirements, I would like you to prepare a tip sheet for employers on this topic. I would like to see the draft by next week. I wrote back, my decision in this case was based on the employer's policy, which prohibits behavior which would reflect poorly on the company, quote, at company-sponsored events or social gatherings, unquote. In this case, the claimant's behavior occurred in neither of these circumstances. She wrote back, certainly a social gathering with thousands. So I am asking you to write a tip sheet for employers for guidance on company policies for employees to understand what rises to the level of upholding the denial of unemployment benefits. I wrote back, but it was not a, quote, company-sponsored social gathering, unquote, as specifically stated in the written policy, but I will comply with the tip sheet. So I sent a tip sheet, but she didn't find adequate, so on the 8th of November, she wrote, We don't really need the case law. I do not understand how these tips would have assisted the bank. So there must be more to add. So, yeah, she didn't exactly tell me how to decide the case, but once I decided the case, she certainly had things to say about how I had decided it.
How did that make you feel?
Very annoyed.
As she being your supervisor?
I felt it presumptuous. I felt it was pressure. Well, you ruled against an employer. You ruled against the bank. How dare you do that? I mean, that's the tone it took. It's like she took it personally. I expect this kind of communication from the employer involved, not from my supervisor. If the bank had been annoyed, okay, I could have accepted this. They had a horse in the race. Director Whaler did not, that I know of, which is not to say she didn't. I don't know. But this certainly sounded like she was personally affronted by my decision. How is this going to assist the bank? I'm not interested in assisting the bank. I'm interested in the facts and the law.
Judge, naturally, I was pressured on certain types of cases. I've been writing myself, Randy Stevenson, I think Susan, took a stance that was 35 years old on involuntary quit cases. And we continued writing these cases. And lead workers wrote letters, emails, copies of director in, and continually wanted to make an appointment for us to go talk to the director about it over a period of months. And did some legislative history stuff, and it slowly but surely they went away. But the pressure was quite intense, and Randy Stevenson thought we were going to get fired over it. It was very clear they wanted us to change our position on how we wrote involuntary quit cases, and the pressure was direct. It wasn't subtle, it wasn't a tip sheet, it was you need to change. So, yeah, there's pressure. Also, you know, this is kind of a lead worker program, and I think sometimes lead workers take a little too much for granted on their position. And just recently, just a couple months ago, I was given a directive that I have to use a different form for non-pro tom. I took issue with it, but I can't really take issue with that. A different form for non-pro tom orders, non-pro tom. If you make a mistake, a scrivener's error, use a non-pro tom. And you know, I wanted to use a different order. Lead workers aren't supposed to be our supervisors, you know they act like it. But they wanted word processors, you have to use this form, so I couldn't do anything else. So I asked them to put on the meeting agenda, which is a way to resolve the problem, because there was a problem with this order, and it didn't get put on, and I was get put on again, missed again, and we haven't had 80%. We'll get it straightened out, but you know, this whole thing with the director not understanding the law, letting lead workers do a little more than they probably should do, just doesn't work. We need to stick with the code of ethics. We need to have a lawyer to report to who understands the problems, who's done these cases, who's been there. It just isn't working. Just doesn't work. And you know, people shouldn't tell me how to write my non-pro toms. The problem with this one is, once we do a non-pro tom in the form they use, can't be searched on the web. Small problem, but every decision is supposed to be searchable on the web. Can't do it. We'll get it straightened out. Just another example of loads of judicial independence because of a system that doesn't work and is still suited to the judicial board.
I just noticed since the lead workers have taken over that we've had email after email after email talking about how we're going to resolve a certain case, this type of case. I probably 5 or 6 or 7 different types of cases, and Devon's the one who led that, and always saying that this is an attempt to be more consistent, and it was just a lot. I mean, because we're getting all this, at the same time we're doing our 30 hearings a week.
Well, you know, there's a good point that Susan brings up. Before Director Whaler came, our assessment was based on 20 one-hour hearings per week done in 40 hours. That gives us 2 hours to do a case. When we get a case, it's great. We do everything. We get the case, we do our motions, we do schedules, we write a decision, and it's not off of our schedule until we write that decision. Sometimes 2 decisions. It's not all of these. You'll see on my schedule here, I have over 30 lines, because there's double file on the cases, there's half-hour files. When the Director Whaler changed that, to 30 cases in 30 hours, plus another 10 hours of department projects, and we've had a lot of extra projects to do. It was just too much, too fast, not enough information, and it's really demoralized the Bureau. It's tough. This is a tough job, not because you have to be an intellectual genius. It's a tough job because you have to have stamina. You go into these hearings, you're constantly dealing with conflict. It's every hour, and it's just that slow, repetitive trauma that beats you down. So this is just a grueling schedule. And everybody in the department is working over 30 hours, over 40 hours a week, and they've been doing that for years. And that's,
Well, that brings me to my next point. How are cases assigned, and who assigns them? Because you had mentioned the changes in the schedule and the fact that Mr. Walsh, Judge Walsh, would hear cases as well. And now we've gone from 14 law judges to 9 law judges. And so my question is, and some weeks the line workers, the lead workers, the lead workers, another part of my life is coming out. In some cases, the lead workers would hear cases, some weeks they would not hear cases. Some weeks you get piled on, some weeks you don't.
We've got the same schedule. It's a static schedule for us. I don't know how lead workers get it. We just look at their cases every once in a while. Sometimes they'll have none, sometimes they'll be 2, sometimes they'll be 15. Sometimes, and I've been at twice, it's been up to 20 sometimes. But it's small in comparison to what we do. And that's the thing. I sent an email to Director Whalen saying, listen, if we put everybody on a full schedule, we'll all be down to about 24 to 26 a week. This is just going to take the pressure off. And she always responds to my emails, but nothing happens to it. So it's really, if we could just get everybody on board doing it, now that training has been so bad, we're losing the experienced people are usually the higher efficient people.
So is this being budget driven to go from 14 to 9? What's driving it?
Well, you have 9 that do a full-time schedule and 4 that do part-time schedules. So you still have a good number of ALJs. One person is part-time because he's, I believe, getting ready to retire. And so that has nothing to do with any of what we're talking about. But we have 3 lead workers who are running part-time schedules.
So Walsh got laid off for budgetary reasons.
He was ALJ number 15, and we had 14 left. So we're still at a pretty good staff. I mean, we have 13 ALJs. I believe that's the right number.
So is there a problem with the way cases are being divided up between you that's creating?
The problem is we have 9 that are doing full-time caseload and 3 that could do full-time caseload if we didn't use a lead worker program.
Why are they doing that?
Well, it's the director's decision. She decided to have them doing projects other than acting as ALJs. I don't know what they did. I know that about half the time is done as an ALJ hearing cases. What they do with the other half of the time, I don't know, and that's unprecedented. We've never done that. I've never seen a time, ever in my time, from 1991 till today, where you had more than one ALJ that did less than half-time cases. Everybody did full caseloads from 1991 when I started all the way until today. It's always been that way. Now we have 3 people that act as quasi-managers and do partial caseloads.
So they're still being paid full-time?
Oh, yeah, they get plus 15%, according to what I heard today.
What do you mean plus 15%?
Well, they get a 50%, as lead workers, they get a 15% differential.
Oh.
They're 115% of what we get.
Okay. And they're doing half or less than half of the work that caseload work that you're doing.
Yeah, a number. And
whatever they do in their other time, it appears they're very efficient with email. So that explains a lot on how cases are assigned and how resources are deployed in the department. I want to get to hostile work environment, and Bonnie, if you could talk a little bit about your decision to retire and maybe what caused that, and you mentioned hostile work environment, so I'm just going to toss the ball to you and let you talk.
Joe Walsh was removed as the Chief Administrative Law Judge on July 15th, 2013, and at that time, Terry Hillary and Davon Lewis were appointed the lead workers. Ms. Hillary had already been working in the office for a period of time and had been, for some months, the lead worker for the support staff, the clerical work. One individual filed a complaint against her, a union grievance for harassment, hostile work environment, and Mr. Walsh removed her in response to that grievance from all supervisory duties for a year. Well, a month later, she's appointed as the worker again. And on July 15th, 10 days after she was appointed, I would come into the office once a week. My day was Thursday afternoon. And word had got out that we were spending, judges and clerks were spending too much time chit-chatting with the scheduling clerk. She had a lot of work to do. We were supposed to stop that, which was fine with me. I thought that eminently reasonable. And so I walked by her desk that day and I said I'd stop and chit-chat, but I understand we're not supposed to waste your time. Now, I don't know whether it was the manner in which I said it, but she took offense, and rather than say something to me, she complained to Terry Hillary. So I was in what we call the ALJ room, where our mail slots are, inboxes are outboxes, and next thing I know, Terry Hillary came quite aggressively into the room and said, "Who told you you weren't supposed to talk to Joni?" Just in that tone. And I said, "I don't think that's important." And she berated me for a period of time, saying, "Well, how would you like it if somebody said that to you?" I said I could probably either speak to them myself or really wouldn't get a rodent's rump. Well, I'm the lead worker, and it's my responsibility to deal with this, and et cetera, et cetera. And I had declined to give her the fight or flight response she was apparently seeking. And in frustration, she left the ALJ room, and as she was leaving, said, "Fight me!" Okay.
Nice.
I did mention this specifically to Ms. Waylard on September 24th when we talked about the ethical considerations of her being a non-lawyer. And her response was, "You don't deserve to be treated like that," as if that was news to me. But I said, "This is not the quality of leadership under which I care to work." And she has refused to carry through with the grievance resolution as done by Mr. Walsh in June of 2013, and Ms. Hillary has remained the lead worker. Whether or not Ms. Waylard said anything to Ms. Hillary, I would not know, as such things would be confidential, but another complaint was filed against Ms. Hillary by the workers' compensation word processors, because Ms. Hillary was berating some of the judges' offices are directly across the aisle from the workers' comp word processors, and she was berating two of the other judges and had created such a hostile work environment that the word processors filed a complaint with the Human Resources Director. So by that time I had made my decision to leave, and I did not involve myself with that, but that was the precipitating event.
Any other examples of hostile work environment?
I think I'd quite a few.
Okay.
Things were so stressful last August right after Joe left, back the day after, I guess, and Teresa said that she was chastised by Joe or counseled by Joe for gossiping, and as part of the gossip is she was telling that Joe was going to bring in certain workers for being late before Joe would make that decision, and those workers were brought in. She was also saying certain workers that they're going to be gone, and I was on that list. I wrote the director an email, a very lengthy email on August 16th, and it's one of the emails that Senator Dotzer has used, and I said that the workplace was a hostile workplace. I said that more people are going to be having to take FMLA. I talked about and in this email I talked about the late call list, because there were some judges who had a lot of calls on there, and I felt like I could act on their behalf since I only had one. But I looked up the one and it was inaccurate. And I explained in the email, they're documenting everything we're doing wrong. it's not a focus on the positive things, the accomplishments. It's everything we're doing wrong. And the director wrote me back and said, Susan, as I've discussed with you, and that's in my evaluation, there's no hit list. And she goes on, the only way people get off center is they don't tell her what's going on. And then again, she says, as we discussed, and it was a pretty nice email. I sent John Nelson the email, and he sent me a form to fill out the hostile work environment. After I had contacted John Nelson, I got a second email from the director in which she said, I'm surprised that as I have read this over many times, I recall that you brought up none of this in our private conversation last week. The first email, she talks about me discussing this. And I subsequently wrote John Nelson and said, I'm not going to be filling out a hostile work environment complaint because I'm paying now for speaking out. I said, everyone's terrified to speak up, and they're smarter than I am. On October 7th, I wrote Teresa Hillary. She's my coworker. The director, when she first put them in, she said they were pseudo supervisors, but they weren't our supervisors. And there were 2 people that day after our staff meeting that were crying. And I wrote an email directly to her, my coworker, and asked her why she had bullied people. And she forwarded it to the director, and the director wrote back to me and told me my accusations aren't based on facts, there's no hit list, others' personal issues aren't my concern. She really values problem solvers, not problem creators, and that she might understand that I don't agree with her, but I'm supposed to bring my issues to her. And at the end, she said, please tone down the name calling. And I replied to every point, which I didn't call anybody any names, and I explained everything that I was doing. There was an email where we all have initials that determine who we are. So Marlon's M. When I first went there, I was B. I got remarried. I stayed with my B. And Beth Sheets, she's S2. Well, for some reason, Davon Lewis likes to use initials. So when you're reading her information, it's like, okay, who's that? You know, and well, Beth Sheets is BX. And Beth had talked to Dan way back, you know, and when they were talking about how they were going to do this, and he said, no, that you shouldn't go like BX. And so Beth contacted the director and said, can we please not refer to me as BX? And the director wrote her back, okay, we'll refer to you as X. And Lynette wrote the director back and said, we usually refer to X as the cases that go over the DIA, and there was no reason for that. When we already have initials that we've been using for, 10 years, 11 years. This is the email I wanted to talk about, and it was Davon. She sent it to another ALJ, and it was about a complaint call, and she took the complaint call, and that's fine. But she shamed this other coworker, and she talked in this email about how the judge had a sing-song tone of voice with a terse scolding tone throughout the hearing, that she told her no one's on the stand, in a telephone or even an in-person hearing. She told her it wasn't administrative law, not a civil or criminal courtroom. You gotta understand, we've all been there for 10, 14, 20 years. She goes on to discuss further, and she describes the judge's language or tone as a smarmy tone. And then she goes on down and she said, she's quoting the judge, and she said, in your kindergarten teacher voice, audible sigh, whispery teacher voice again, audible sigh, kindergarten teacher voice to close of hearing, airline attendant sing-song voice. And at the bottom of this, she said the judge sounded patronizing and condescending to the employer. It's like, well, what is this? I mean, it's so offensive. The judge was so upset. The director was copied in on that. She tolerates it. We have to have our bi-weekly meetings, and sometimes they're canceled, but we go to these meetings and there's members of management lined up the wall, kind of like they're lined up today, although Harry Kuntz is not usually there and the deputy director isn't, but more importantly, John Nelson. So, from Human Resources, thank you. So we go to these meetings and we don't feel like we can discuss the law, discuss any issues. We spent one meeting, and this is taking time away from our writing, and we spent one meeting, Lori Adams talked about acronyms. I mean, it was over an hour. And the meetings were always the judges. We always had a vigorous discussion between us about cases.
So let me just stop you there because I want to get to one more question that I know I want to hear about. Have any of you been instructed not to talk to legislators, not to talk to anybody from the press, not to talk to anyone from outside the agency about anything related to morale, working conditions, or hostile work environment, or anything that we've covered today?
I was called in for a potential disciplinary action. I had to have my union steward there, and what it was is that one of my emails was used by Senator Doxler, and then the media got a hold of it. And they were accusing me of altering it. I'm not the one who provided the email. They said I'm the only one who sent it outside the agency. They asked me if I sent it to other people, and I said absolutely. And they asked who. I said aunts, uncles, cousins, friends, all over the United States. And they asked if I provided it to a reporter. I said I did not. They asked if I altered it. I said I did not. I didn't understand. And what the issue was is that when I initially wrote the letter of the hostile work environment, I sent it to my coworkers. I'm the one who did that. Okay? When the director wrote me back, it doesn't show who I sent it to, and I didn't know this until after the fact. But it appears as if she's the one who sent it to everybody. Well, and there were two emails, and the paper got the second one, and the paper wrote an article and said, well, the director sent it to everybody. Well, I never, ever alleged that I didn't send it to everybody. And I was scared to death getting called in there. I never knew who John Nelson was before. And so I was there. I was questioned. If I had given that to the newspaper, if I gave that to the senator, if I knew who did give it to the senator, at which point my union representative objected to that. And so that was my whole experience with that.
So that concludes the questions that I had. Other than that, it sounds like a great place to work. So I think I'm done with my questions. Anyone else?
Thanks. I had a question about, this morning they talked about the difference between working from home and working at the office. What type of, what happens to your files that are left in the office? Are you allowed to lock those up, or how do you protect the confidentiality of the materials at work?
That's a good one. February 14th, I left the office and I left my Mason City files on my desk. It's an unlocked office. I come in the next morning, Saturday, February 15th, and they were gone. I tore that place apart to look for them. They ended up coming right back to that same office and into a drawer, which I looked in 3 times, and so I two of my coworkers. Sometimes our files come up missing when people get mad at us. So, we need a better system to do that. We are behind locked doors for the whole west wing. But now I have a key to my office, and I'm very happy with that. But the files go into that west wing. We have locking doors going into the wing, but everybody in the wing, all 3 floors, have access to those files. So they're going to walk through our doors and come in and look at them.
Okay, so I'm trying to think back. One of you had mentioned that certain people had keys, and they would leave. Had keys?
No, there's nothing locked there for files. The files are in
No.
Yeah.
Okay.
Well, the offices, everybody has a key card, a badge that you can get into that wing of the office.
So I went to a case before you, there's no procedure for making sure that those files are kept under lock and key, and that you're the only one with access to them, except for.
All the LPAs have all access to all files, just in my belief. Except for three locked offices.
I saw that. Senator.
I brought a study. I talked to you about the depletion effects of overworking and how it can change judgment and the burden of proving cases. I'd like to have about 5 copies. So if I could give those to folks for you to read, it's an interesting little study. I've seen many of them like this.
Thank you.
Okay.
Senator.
Thank you, Madam Chair. Mr. Mormon, I am just a little confused in listening to your testimony here, listening to the earlier testimony, as to exactly what the caseload is of the administrative law judges now and in the past.
Now it is 29 hours per week. That doesn't count the cases, because some cases are double file numbers, and some cases are half-hour cases. But it's 29 1-hour slots per week, and some 1-hour cases have 2, 3, and even 4 and 5 files. Some half-hour cases have 2 files. As a general rule, a 1-hour case will be 1 file, a half-hour case will be 1 file. If you take 1 hour and put 2 half hours in. So, like, for example, this schedule, I think there's 35 lines on it, so that would be 29 here, or 39, or 35 files in 30 hours.
Okay, well, now, is that different than what it was 3 or 4 years ago, say?
Well, last year it was 30, then we went before that, about a year and a half before, it was 28. Before that, 26, and I think we were, as far as I can remember, 24. I had that at home, and I don't have it with me. Sorry, I used to know what the numbers were, but over the last 5 years, it has just gradually gone up. We were, I think, at 20, back in 2004 or 5 for a period of time.
At 20?
Yeah, we were as low as 20 and 25. Maybe even a little lower on some odd weeks. That lasted a very short period of time.
Well, what I'm trying to reconcile is the fact that everybody concedes we were way behind on getting these decisions out. Just, I don't know, a couple of years ago, I guess.
Yeah, I think what you're mixing the apples and oranges. I was never behind on my current caseload, but the cases they gave me were old. So it looked like I was turning in stuff within a few days of hearing the case, but those cases were over 30 days old, so it gave me the time that's measured. That's the difference.
Now, is that the case with all the judges then?
No, everybody's a little bit different, and we have some folks that got behind.
Okay.
When the numbers went up in 08, you know what happened in 08, and that's when our numbers started going. We hit a peak of 18,000 cases in 1 year, and you know, that was a tough year.
Okay, so some judges were behind and some weren't.
Some were behind in getting their cases out in a reasonably fast manner.
Yeah.
Turnaround time of 1 day from hearing to decision. Others that got behind and were, I know, Terry Miller and Devon Lewis have often had times when their cases were 90 days old. And they said, you can get behind if you're not careful. Everybody gets behind.
Well,
I haven't got behind.
Okay, well, you did a great job. Good.
Well, not necessarily. I'm exhausted.
I'm trying to put all this into context because everybody agrees, well, I don't know if everybody agrees, but as I understand, we get money from the federal government, and one of their conditions is we have to meet certain guidelines and timeliness, turnaround time.
We're talking about two different guidelines. Here's the one where you're getting mixed up. I know exactly where you're off.
Okay.
You explain this to other people and it gets difficult. I have a time guideline for me when hearing a case. How long does it take me to hear the case and get a decision put in there? That's one timeline. That's not a DOL metric. We have another timeline. What's the time from the time that case is filed till the time the decision is written? That's the one they're talking about. That's the DOL timeliness metric. Date of filing till the date we send the decision out to the mail.
Okay.
That's the one I think that you want to talk about.
Okay, and that's the one that we got way behind on.
Yeah, we got behind, we got 18,000 cases in 1 year.
Well, but as I said a while ago, I hear you saying that, but as I understand it, at one point, we were ranked 47th among whatever it is, 52 jurisdictions.
I don't know what that ranking is. I didn't keep track of that.
In terms of getting our cases decided. And so I don't understand the argument that, well, we had a recession, we had a lot more cases. I mean, I'm assuming that's the case, but every other state would have had that same situation.
I can answer that.
Okay, please do.
We didn't have enough personnel. You can't, it doesn't matter what you do if you don't have enough people to do the cases. What you have is that time from the date it's filed to the date you got to get a decision done, but your cases stack up because you don't have enough people to assign them to. We're all doing the same number of files every week, but if you don't have enough warm bodies to take more files, you don't get it done.
Okay, so, and you may not know this, but are there guidelines from the federal government on numbers of cases that an ALJ judge should be able to decide? Are there standards?
Every state is different because every state's law and procedure is different.
No, I'm not asking about
No, there are no guidelines I'm aware of, sir. No.
The federal government, Department of Labor, does not have guidelines.
None that I've ever seen, none that I've heard of. We've always looked at other states to kind of see what other people do.
All right. And you have looked at what other states? Midwest states?
I think the last email came out was mostly Midwest states. Iowa, Nebraska, Wisconsin, Kansas, as I recall. We had an email on that record waiver check went out this month or two back.
Well,
I remember because I responded to the letter saying they're comparing apples to oranges because their procedure and methods of writing decisions is different. If you hear a case, which is the fun part, and then all you do is check boxes, that's not a bad way to do it. I can do a lot of cases doing that. But if I've got to write a due process decision, it's a different story.
are you aware that there were issues from the Department of Labor on funding because we weren't keeping up the way they thought that, the way their standards require? Are you aware of that?
I've heard that many times over my 24 years, that there are times when we're having trouble with funding because we're behind in cases. But I don't have any, I can't answer that and tell them. I don't have information. So.
It's kind of hearsay. You've heard about that. You don't really have personal knowledge.
The chief makes a few comments about it. We've got to try to figure out where to get the numbers up.
Okay. All right. I guess the main point is now we have got the numbers up. Is that correct?
Yeah. Well, the main point you're making, the main point I'm making is at what cost. The most important factor, the most important metric we have is who wins and who loses. I brought this up at the staff meeting after staff meeting. It is important to figure out, have that balance between how many cases you get out and who wins and who loses. Because if you lose sight on that, it'll be like the floods of '93 where we did craft work. By Thursday afternoon, we were so tired, I didn't think anybody got justice on Friday. It just wasn't right. You've got to have that balance. That's what due process is, that's judicial independence. So, you've got to stop somewhere. You can't just keep piling work on because we want timeliness metrics. It's not fair.
I want to be really clear on this because I think what I just heard you say is that some of the decisions that are being made are not the proper decisions because the judges are overworked. Is that what you're saying?
My opinion is that as you move up in the caseload, you will have a depletion effect. That people just generally move to a default. The default is who has the burden of proof. For example, employers have the burden of proof in discharge cases and firings. That's the majority of our cases. Workers have the burden of proof, initial burden of proof, in a quit case. So as you move up and you do more and more, that's a general rule, that depletion effect will hit. and it will take effect, and it will cause injustice. And I think if you look at the numbers and what's happened in our state, I think we've seen that depletion effect over the last 5 years, where we've gravitated more towards workers than employers because you have more of the discharge from misconduct cases. That's my opinion. You take a look at the study and read it. I've done some jury work. I don't send the jury. I wouldn't send my case to a jury that's retiring money. That was just a general rule. I think the same thing applies here. You've got to stop somewhere. You've got to call that. And nobody does it. That's what my problem is. And I've been making that complaint. I sent emails. I think we've hit that point some time ago.
So when Mr. Walsh was, I would say, kind of boasting that he got us caught up, you're saying, well, but at the cost of proper decisions, is that right?
We were doing 24 and 26 with him, and finally I think we went to 28 or 30, and he said, this is temporary, we've got to cut it back. He told me, promised me, we will not leave this as a permanent number. This is going to be a short sprint, and then we'll start getting these numbers back down. That was his promise. And every chief ALJ has been in this situation, and they've all come there sometime, have said, never again will I take it, put that many cases on people that it send out practicing. I'm speaking with experience. That's all I can speak with in this matter. I think I'm right on it, and I think I have a lot of people that will back me up on it, plus statistics and studies. So, if you don't want to believe it, that's fine.
Well, I'm asking your opinion. That's the whole point. That's the whole point of what we're doing. Now, what about the working at home? We've heard a lot of discussion on that. Is it coincidence that cutting down the hours of working at home has happened at the same time as we got caught up?
Yes.
That's just pure coincidence.
It's management tactics, the management cracking down on those folks that made people get caught up. It wasn't because you changed from home to office or home. It'd be the same thing. A lot of them just rather, we're going to completely take away the work at home, so get caught up. So people did a lot of late nights and a lot of weekends. There's people that work all weekend long sometimes with they get behind. And I know people, and I know Devon and Jerry is bragging about doing Friday nights and doing all night. It's not just us. Everybody gets in the situation. Not everybody. Bonnie never has. She could always do this job in 40 hours, but she's fast. Some people just have an ability to do it, and others got to work their tail off. Everybody's a little different. You got a little different chance.
Do you know if there were agreements that were signed between any of the judges and administration regarding the rules and regulations for working at home?
You see, we need correction on that. Director Wayland asked me to rewrite that policy. It has to be a policy. It can't be a contract, it can't be agreement. So we have to follow the policy because otherwise it's collective bargaining. And when Director Wayland asked me to do it, I said, I really don't want to do it. I think it's a government lawyer. And she said, I want you to do it. So I wrote it and wrote it as a policy. My advice is we have to have a policy. And so I wrote the whole thing. What do you need to know?
When was that?
I think we started in October or November of last year, and we have knocked out in the middle of January. She wanted a January one, I think we were mid-January.
All right, so before that, there wasn't any policy.
There was a reason for that.
Okay.
We sat down and talked about it, you don't want to know. So.
I just asked you if there was a policy. If there was no policy, that's what I understood you to say.
There was no policy before. No.
Okay. All right.
It was intentional.
All right. Certainly.
Thank you. Thank you all for coming to testify today. I know it's difficult for you to do. Just a couple of follow-up questions. First of all, Ms. Ackerman, thank you for explaining the email with Director Whaler. That was one of the questions I had actually, because the copy of the email that's on the Senate Democrats website clearly omits the original header, the two from the subject lines from the original email. And the Des Moines Register article, at least, it was clear from the way that article was written that the reporter was under the impression that the original email was just from you to Director Whaler, and that Whaler in turn replied to you, but also tried to embarrass you and humiliate you by carbon copying all these other people. And that was ALJ's. I'm sure you'd agree that it's important to present every side of an argument fairly and paint everyone in the accurate light.
Right.
So I appreciate you mentioning that.
Can I add that I didn't know why it printed that way until there was another battle, if you will, emails between the director and me. And when she sent it back to me, it's like, well, that's why it doesn't show. And I sent it to Carrie Coombs and said, do you want to know why the email was like it was? It's your email system. That's how it does. I had nothing to do with it, and she thanked me for letting her know that. But, I mean, they questioned me. I didn't know. I didn't talk to the reporter, and I understood what they were saying, but I didn't have anything to do with it. And it was kind of scary going in there.
Sure.
I mean, this whole thing is
And
kind of
the
scary.
Democrats may have gotten it that way too. I don't know, but nevertheless, it appears that way on the website.
Senator Schneider, I want to just interject quickly and tell you that it is on the oversight website from a public information request for our committee. I'm not sure if they're referring to any other times it's been used.
Yeah, the link to Senator Dossler's press conference includes.
But the materials that we requested are directly.
I'm not using that.
I just want to make
stating.
sure that people on the committee know the material we're using came directly from the department.
Okay. I'm just stating what's out there. So that's all. I'm not blaming you or using anything, but.
Just clarify.
Sure. The other question I have is, I understand working from home. I don't have a problem with people working at home. Our company has a work at home policy that works very well for people, and frankly, I think it helps us attract and retain a good workforce. I'm just curious to know what, and I think Mr. Mormon answered this already. I was just going to ask to what you each would attribute the sudden increase in responding to or issuing a decision within 60 days of an appeal being filed to 30 days. The 60% compliance or 60% of decisions being issued within 30 days after the first appeal was filed. So if there's no causal connection between the sudden increase in meeting that metric, to what do you, and I think Mr. Mormon already said it was the change in management and cracking down on.
If I could respond to that, though, something that seems to be missing from the view of things, as all of us can attest to, in unemployment, things go up and down. I mean, for years, we couldn't even hear the cases within 30 days. And then we got beyond that, and then we did. It's not as if when Joe came in, you know, he just screwed everything up, and then the director came in and saved us. She's done a lot of positive, and I'm not saying she hasn't. But unemployment, the claims, everything, it fluctuates. And so you've got to keep that in consideration, or keep it in mind in the first place, and in the second place, I think it was a management style of fear. And the one thing that could be held over our heads was that we got pulled in the office. And, you know, as Bonnie said, you can work at home when you're sick. I had a couple months back where I could not work in the office. I had medical issues, and I told the director, I can do my hearings at home. She wouldn't let me, you know. So it is fear, and fear of losing our job, fear of getting pulled in. So that's a lot of it. But more importantly, unemployment fluctuates, you know, and that depends on the number of people we have. We can have several people who are out on medical, even if we have the right number of people. If a lot of people are out on medical, you know, that's going to skew the statistics. It's not like, you know, Joe was just, oh, I don't care. I mean, there's so many factors that are involved in this And
I think to some extent, as I said before, the very upsurge in cases during the economic downturn in 2008, 2009, I mean, we were scooping that up since till the mid of 2010, I'm quite sure, or longer. But you see, the cases, in a sense, became easier, and let me explain. When this huge upsurge of unemployment claims came along, it was generally going to be laid off, or fired, things like that. And there were cases then where you had to kind of pick up the crumbs that they dropped, because the people at the claims level were trying to get the main issues adjudicated out the door. Do these people get unemployment benefits or not? You know, get those resolved first. I had cases where a separation had occurred in, let's say, February of 2009. And a decision was issued on severance pay in June of 2010. So, well, why did you wait this long to say I don't get these benefits because I got severance pay? Well, we were trying to get the cases out of the way that say whether you get unemployment benefits or not, and we're going to worry about picking up the other stuff once that surge has passed. So those cases were easier. Did you get severance pay or not? Okay. Did you have to sign a contract to get your severance pay or not? Did you get vacation pay? Did you get any kind of compensation? Those could be taken care of later, and they're a lot easier. That's just dollars and cents. Did you get severance pay? What was the amount? Do you agree that this represents X number of weeks? Bam, that's a two-party hearing, but it can be done in 10 minutes. It got easier because we were in that backlog. And like I said, some of these separations had occurred 18 months before, but claims had been so busy with the initial issues of basic eligibility, qualification for benefits, that they worried about the housekeeping things later. And yeah, the decisions got easier after that big surge had passed. And then we're just dealing with dollars and cents, vacation pay, severance pay, things like that.
And just to go back to the undue influence issue, just to be clear, no one has pushed you to decide a particular case in a particular way. I haven't heard anyone suggest that.
No.
Well, yes, I have.
Okay, yeah, yes.
And the involuntary quit cases are myself, Randy, and Susan, we're all pressured to try to change our rulings in those cases. And it went on for months. They were pretty tough on us. Finally got away. We stuck to our guns and we didn't move from that, but yes. There was a full-blown assault on judicial independence on that issue. Same thing on Norfolk, that's how we should do those. But you're wrong.
But as to a specific case.
No one's ever given me to move this way in a case.
on this person.
No, but change my rulings on a group of cases, maybe involuntary quit, yes. Absolutely.
And quickly too about the metrics, I don't like that word much, but they're down three judges. I retired May 30th, Vicki Seek retired May 1st, Randy Stevenson, his last case was in mid-August. The replacement, the hiring of judges moves at a glacial pace. We were down 2 judges for 2 years. I mean, Carolyn Coleman and Dan Anderson, Carolyn had been deceased for, 2 years before they even thought about replacing her. And then the training for these new judges took months. I was doing a caseload after 2 weeks, and so was the other judge that I mentored. We were doing a caseload, at least half caseload, after 2 weeks of training. The new people they hired didn't do their own caseload for several months. The training has now been decided by the lead workers, and that moves at a glacial pace as well. And you're going to see you're going to see an upsurge in the number of cases that can't be met within 30 days because you don't have the personnel, as Judge Mormon had said. You don't have the bodies in the office or at home to do the work you need to do. That needs to be addressed too. More efficient training, quicker replacement and hiring. There will be a problem with that, I'm quite sure.
And just a final question too, since we've asked this throughout today, I think all of the witnesses, but have any of you met with Democratic staff or individual legislators or group of legislators prior to today's meeting?
Well, there were a group of us that met with Senator Gottsler, back in
March 17th, St. Patrick's Day.
Okay. I attempted to meet with Senator Garrett. We're friends from our kids went to school together. We both coached trial teams at the same school at the same time. I knew wife Marianne before she passed. We had a history. I tried to meet with him. I tried to discuss the problems. I tried to convey this is not partisan. And he was involved in stuff, and so that never happened.
In that meeting you referred to earlier, any others, have you been asked to be prepared to testify on any particular matters, or to respond in any particular way, or to present particular facts?
No, at the meeting, I believe Senator Gottsler said, would you be willing to testify if it came to this, or if it came to that? And I said yes, because I'm so upset about the way things are going. Martin said yes, and Bonnie said yes, which I guess is why we're here today.
And have you sent any documents to any legislators or staff members in preparation for today?
I've sent emails to Sue, but not in preparation of pointing out a lot of the documents that were on the website, the subpoena documents, because there's a lot of documents there. And if I saw one, I'd send it to Sue Becky, but I haven't talked to any legislators.
Nobody approached me. No, I was there when Mr. Dawson was there. There's no coaching. I didn't talk to anybody. The only thing I just got together with Susan and Bonnie. We sat and chatted, trying to figure out an intelligent way. There's so much information. We try to find somebody quickly convey our story. That's what we did. But no, we didn't talk to any of these folks. I've never met any of these folks before today.
We've already. Okay, thank you. I don't have any other questions.
Thanks, Senator Schneider. Just for sake of the committee, we did say we would adjourn at 4:30. Joni Henson was our last guest, and we have moved her to tomorrow morning. But Senator Schneider asked for some of your final questions. Do you have additional questions, Senator Garrett?
I do have one, and I'm also, well, let me answer the question first, and I have a point I want to raise. Mr. Mormon, in light of your testimony just before I yielded to Senator Schneider, you heard Mr. Walsh's testimony, didn't you?
I really wasn't paying attention. We got pretty long. I stepped out a number of times. I'm not saying your cross-examination put me to sleep, but it was close.
Well, I'm sorry. Did you hear him taking credit for turning around the timeliness of the decisions getting out?
Yeah.
Okay. Now, I just want to ask you, in light of what you just said before we left off, I gather that you don't think that it was because of something he did that the timeliness went down. You said it was other things. Am I right about that?
Two different kinds of timelines that we're talking about here. One is individuals getting their cases done quickly from the date of hearing to the date of decision. The other one is from the date of filing to meet our 30, 45, or 60 day metric, 90 day metric. Two different kind of things. Joe Walsh did several things that moved up our numbers. He increased our caseload, and then we had numbers starting to go down because the economy was starting to go down. Those were the things that happened. So yes, he did make improvements in our timeliness metrics. That's my belief, based on that.
Okay, so your caseload went up enough to impact the tardiness issue?
Oh God, the caseload went up just phenomenally. We went from like, I don't know, maybe 10,000 cases a year to 18,000 at a top. It was just a huge increase.
Well, I was thinking in terms of the caseload per ALJ.
Yeah, he did increase it. Over the time he was there, I think he increased it by 2 or 4 cases per week. With the promise it was going to be just for a few months to try to get over a hump, because we were real close to a certain point, and then a certain message. He wanted a couple months so we could hit that, and that's why it went up. He said it's going to be temporary, but Whalen came in and kept it, or went higher when I kept it. I'm not for sure.
All right, so I thank you for clarifying that. I wasn't entirely sure what your position was. I understood that was the case, but the numbers projected on it. I thought, and I'm sorry, I misinterpreted, I thought you were disputing that, but I get it now you're not. You're agreeing that that's the case.
That makes me happy. You know, Senator, I'm a lifelong conservative Republican. I don't want to quote anchor on the Republican Party, but you know, folks, you got to accept there's some problems here. I want you to take ownership and try to work on those problems for us. I don't want Republican or Democrat in my hearing room. It's completely out, notwithstanding my political beliefs. I never let that in there. Just to help us get back to that point where the people aren't worried. I get calls all the time, people saying, "You guys all right? Am I going to be in fair shape? Is there some politician going to tell you what to do?" We got to get away with that. This should be totally non-political. It's not.
Look, I take a little offense at that. I have never, ever said, or made any statement that political considerations ought to be involved in any of these decisions. I don't know that Senator Schneider has.
No, I don't think you have.
Well,
what the here's paper is, at will, at Chief Judge and Inspections of Appeals at will. Chief Judge tried to be made at will, in the appeals bureau. We just got to be aware of that. I'm just asking you to consider what we're saying. So I'm sorry to offend you. That's my opinion.
I think we all agree that the judges should decide the cases on the evidence, on the merits. It sounds like they have. I haven't heard one judge say that they've done anything other than that. So,
I think you're right. I think it's this aura of political influence that's the rule gets violated. You have to have the appearance of no influence also, and that's what all the rules say. It's the appearance of impropriety. We seem to have a dark cloud right now. Let's get rid of the cloud and go back and work out. That's all we want.
well, all right.
Can I add, actually 2 points, and I know you want to get out of here, but, I had in-person hearings yesterday, and before we started, I received a motion from the attorney representing the claimant who asked that I recuse myself and asked that all the ALJs at Workforce recuse ourselves, and he wanted the case transferred over to the Department of Inspections and Appeals. And it's based on the perception that there's political influence. And I'm not the first one to have dealt with this. And we're supposed to promote public confidence in the agency. Actually, the agency is supposed to promote that, and it's a problem. I explained that I marked it as evidence, and it's part of the record now. And I have to explain why I'm making the decision, but I told him I believe I can make a fair decision, outside of that. But I did face that, and like I said, I'm not the only one. And one last thing, and obviously I speak out, sometimes to my own detriment, but I want to let you know that I'm rather concerned about the effects of how much I've spoken out today, because I've never spoken out in a public forum and said the things I've said, and I feel like my fears are warranted because the director is my immediate supervisor, which means she gives me my evaluation. She sent out an email that the evaluations were to be completed by August. After this hearing was scheduled, she changed that, and now the evaluations are scheduled in September. So she's going to do my evaluation after my testimony here today. And not looking forward to that, I can tell you that. Thank you for listening. That's all we wanted. Appreciate it.
I have one further point.
Is it with our, with the ALJs?
No, well, not with the 3 years.
I want to thank you for coming. I know you do not have a choice. You were subpoenaed to be here, and I know it's uncomfortable. I appreciate you coming forward and telling the truth. And I want you to know that there are people here who truly value your work, and I know you have stressful jobs and difficult positions to be in. I truly appreciate you coming before our committee today. Thank you.
Thank you for hearing us.
Thank you very much. I do want to thank you all.
Senator Jerry,
I just have one more point. The 2 ladies that testified earlier, their names came up several times during the testimony of the other witnesses, and I just wanted to raise the question. I don't know if they do or not, if they would feel like they'd want to have any kind of few minutes for rebuttal. And maybe you do, maybe you don't. You didn't know I was going to bring that up, but your name did come up during some of the discussion. I just wanted to raise that as a possibility.
Yes, I appreciate that. It doesn't have to be today, it could be tomorrow.
have them submit if there's a discrepancy in the testimony, submit some piece that we can form on documentation for committee members, 2 of our committee members are absent. Or point well taken. Seeing no other business, I think we will adjourn and we will reconvene tomorrow at 10 a.m.